Hey, everybody. I realized I didn't click the go live button, which is really important when it comes to going live. But hopefully, I'm live now. Let me pull up my own thing. I got my email saying that I'm live, which is helpful. Email saying that I'm live, which is helpful. Hey, everybody. Hit the like if you enjoy the other stuff rants. I don't remember the other stuff rants. Oh, is that from yesterday? Because I did do a lot of other stuff rants yesterday. It was basically just one large other stuff rant. I know how football works, so I can turn on the sound and hear the oral arguments, enabling cops to come into my home anytime they can make up a halfway decent excuse. Yeah, I'm interested in seeing this argument. I don't really know that much. Again, like I only started doing criminal law like 5 minutes ago. This isn't really like my whole, area of expertise or anything. I'm just kind of making this stuff up as I go along, pretending to be an expert. And I know you guys probably think I'm joking, but I'm really not. Let me see here. All experts have to start somewhere. That's true. We've seen far more deplorable people pretend to be experts. There's no need to bring Trooper Paul into this. No, I'm just kidding. I don't think Trooper Paul's a deplorable person. I think he's just a confused boy. Part of me was thinking about trying to apply for a job at what's it called? The AJ's place. Whiffin Ball. What's it called? What's the name of AJ's firm? Jackson something or other. I can't remember the other guy's name. So now that I want to wait a second to kill some time. He always has his listening ears on. Exactly. I'm going to show you guys something that jumped out to me about this. A couple of things that don't matter at all, but that jumped out to me. So if anyone wants to come, they can have a minute to jump in here. White and exactly. So this lawyer's address is North Last Chance Gulch, and I can't decide if that's like a good name for an appellate lawyer or a bad name. You should come to the East Coast. Yeah, I lived most of my life on the East Coast. I've only been out here for a few years. Oh, I also live down the street from here. And I do live down the street from this one. Wilson Sonsini. West Coast is best coast. Yeah, I grew up in Maine, lived in DC for a while. I've only been to Atlanta twice. Once was for a meeting that didn't happen. That was a lot of fun. I'm generally pretty good with geography, but I had no idea where Atlanta was. I thought Atlanta was a coastal town because it's on the East Coast. It's nowhere near the coast, it turns out. I haven't been west of the Mississippi. The first time I was west of the Mississippi was in college. I had a friend in high school in Maine, and he was he was a party guy. He would drink a lot. Then he went to community college for 2 years. He's really smart. And then he ended up going to Berkeley. It was like his PhD. He would PhD from Berkeley, and he went to Stanford for his master's in like material sciences. But at the time I went there, and I only had like $15 when I got to the Bay Area. So I just kind of wandered around and like ate French fries for meals, and kind of just looked at what are the animals they have out there? They're not seals, sea lions, or whatever they are. Yeah, I was kind of broke. That was during the Four Loco era, so we like went partying. We had like the real Four Locos back when they before they like nerfed them. I do at one point remember being in San Francisco with no idea where I was because I there was like a moment of sobriety that came over me when I realized that I wasn't in a state I was, that I knew. 20s just hit different. I feel pretty confident you won't apply to work for the Fulton County DA office. Maybe as a troll, just to see if they, if they, there's something slips through the cracks. Oh man. Okay. So this is the case that we're going to look at. It's called Case. Funny story. I couldn't remember the name of the case, and so I was trying to Google it last night, and I knew Case was in the name, so I was like Googling Supreme Court, like Case Supreme Court 2025, and that didn't help at all. Case is a really inconvenient name for a case when you're trying to find it on Google. Let me see here. So I don't think we're going to go through the whole brief because I want to get to the oral argument. But we'll read enough to get a sense of what's going on here. Docket number. Yeah, true. So I know this has to do with the emergency exception to the requirement for probable cause. Mostly I just want to see the facts. I read a quick little shorthand of them on SCOTUS blog. Okay, I'll do my little state thing too. Maine to DC to PA. Where did I go after that? DC to California. I'm in Los Angeles right now. It's kind of funny how that happened. I went to law school at USC for complicated reasons. I just kind of stayed out here. Although I wouldn't mind moving out of LA at this point, since I'm not really don't need to be in downtown anymore. But yeah, I lived in central Pennsylvania for a while. In Selinsgrove, Pennsylvania, in the middle of nowhere. San Diego. Yeah, I go to San Diego all the time. Ah, it's really nice. Okay, so we'll get into this. Like I said, the question presented is whether also, these are really hard to write because I don't know how to put them in the form of a question. It doesn't really look like this is in the form of a question, which I like. But these are so hard to write. Whether law enforcement may enter a home without a search warrant based on less than probable cause that an emergency is occurring, or whether the emergency aid exception requires probable cause. I didn't hear about that. In modern ASL, true. Oh my goodness. What a time that was. Let's see. Okay. Petitioner William Trevor Case. Man, I had a whole joke set up and I just realized I missed it. So these guys are from Helena, and I was gonna play a clip from that one song named Helena, but that's okay. The moment is past. The joke is ruined. We're moving on. Parties to the proceeding, its case in the state of Montana. Okay, this is another important thing that we need to spend some time on. There's a county called Anaconda Deer Lodge, and I want to know the background of that because I don't think there are any anacondas in Montana. Maybe there are. I don't know. I'm not an anaconda aficionado. But how did this come about? I would like to know. Judge. That's what I was thinking. Reminds me of Arrested Development when they had like Judge Reinhold, who was going to have a show called Judge Reinhold, but then he didn't want it to be called that, so he insisted on it being called Mr. Reinhold's Courthouse or Courtroom. So, okay, the facts are pretty short in this, so I think we can get through. It's 33 pages, but it's like Supreme Court pages that inexplicably are. Let's see if I recognize any of these actually. Nothing jumps out at me. Yeah, this one. Yeah. Damn, why are they citing? Oh, Terry, of course. Why are they citing so much law? This isn't how you're supposed to do it. Quarterman, I've read this. Our Fourth Amendment. Hey, Allie. 24-point font. Yeah, seriously. Man, that thing, who was that person that was mad at Betero for using 14-point font? I've been self-conscious about using 14-point font ever since that happened. I kept going back and forth because I know Tiffany Adams uses 14-point font. So when I do the Moontunk, yeah, that's who it was. When I do the Moontunk briefing, I was like, I wanted to do it in 12-point font because I was like self-conscious about 14-point. But I did end up doing oh man, I did end up doing the 14-point, even though, it is what it is. Oh, that's right. That's what I wanted to do, Matthew. You reminded me yesterday. I wanted to look at that case, the one with the lettering. That'll be a good lightener of the mood. The font, I mean. Oh yeah, can you send it to me? Send it to me on Twitter. I won't do it until after this, so it's no rush. I'm sure I can pull it up in chat, in our messages or something. Okay, introduction. This case gives the court the opportunity to clarify the contours of the exigent circumstances doctrine as applied to emergency aid situations. This is such, like, it's not bad, but it's very legal writing. It's good, but it's funny to read this after reading double negatives all the time. An issue that has consistently confused and divided the lower courts. In Brigham, this court held that before police officers enter a home without a warrant, they must have an objectively reasonable basis for believing that an occupant is seriously injured or imminently threatened with such injury. That's right. It's shall not commit no typos. The state courts and federal courts of appeals are deeply divided, however, on whether this objectively reasonable basis standard requires police making a warrantless entry to have probable cause to believe an emergency exists or some lower level of suspicion. But isn't it? That's confusing because it's like objectively reasonable is the standard. I don't know anything about this stuff. So you have to have probable cause that it's subjectively reasonable? I'm already confused. These people are too smart. In a 4-3 decision, Montana Supreme Court joined 3 other state high courts, as well as the 1st, 8th, and 10th, in rejecting the probable cause requirement, deeming probable cause unwieldy and superfluous. The majority held that police need only have some objective, specific, and articulable facts from which an experienced officer would suspect that a citizen is in need of help or is in peril. Man, that's even worse. Some objective facts. I mean, how many is some? Okay. This holding echoes the other courts treating Brigham City's reasonable basis standard as a less exacting standard that need not approximate probable cause. Hence the confusion among the lower courts. Yeah, I don't understand. uh it seems like they're different things, right? Like if you have like I understand what objective, specific, and articulable means. Not so much some, but objectively reasonable seems, like a good enough standard. I guess in courts can evaluate what objectively reasonable means, but I have no idea. Okay, I'm learning with everybody else. For these courts, it is enough that officers had a reasonable belief, short of probable cause, that a person inside the home was in immediate need. These margins are absurd. I'll zoom out a little bit just so you can see what we're looking at here. I'm sure it's so the judges can like write in the margins, which I understand. Supreme Court's so silly. Okay. Need aid or protection. Some going so far as to adopt the Terry standard for loaded detentions. Let me see. Montana Supreme Court arrived at this holding over dissent that assessed the presence of exigent circumstances by examining whether there was probable cause to believe someone was subject to imminent harm, distress, or in need of assistance. Probable cause requirement, the dissent reasoned, is not limited to only the commission of a criminal offense. It applies to whether there is probable cause to believe a person is in imminent peril. This reasoning tracks position taken by the D.C. 2nd and 11th Circuits, as well as Nebraska and Colorado High Courts. Officers must have probable cause to believe that a person is seriously injured or threatened with such injury before entering a home without a warrant. Okay. The divided decision here not only illustrates the split among the courts on the emergency exception, but also shows why this case provides a good opportunity to resolve it. Officers entered William Trevor Case's home after his ex-girlfriend reported that he had threatened suicide. It is undisputed, however, that the officers all knew Case had previously, quote, attempted to elicit a defensive response, i.e. a suicide by cop in dealings with police. Is that a section header? Because the officer... This Supreme Court formatting is throwing me off. I'm sorry. The officers believed it was unlikely Case required immediate aid, but rather was likely lying in wait for them to commit suicide by cop. They waited roughly 40 minutes before entering the home. See, that seems to suggest that there was an emergency. If you wait 40 minutes, 45 minutes, what's on SCOTUS blog, it's hard to say that there was an emergency. While the majority believed these facts and circumstances sufficed to reasonably suspect there was a citizen in need of help, the dissent concluded that under a probable cause standard, the state has not met its burden of demonstrating the presence of exigent circumstances. This is thus the paradigmatic case where the standard of suspicion is dispositive. Okay, saying that this is where the court can resolve the question. Just reading the Fourth Amendment here, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the case to be searched, place to be searched, and the persons to be seized. Ooh, that reminds me of a case I want to look at. Ooh, we get to read this again. Okay, this is the statement of facts. This petition arises from the warrantless entry into and search of Case's home by the Anaconda Deer Lodge County Police Department on September 27th, 21. During the search, the police seized evidence used... Man, YNW Melly was already in jail at this point. Oh, thanks, Matthew. Yeah, I saw it come in. So this case went from like the search to the state court, state Supreme Court, United States Supreme Court before Melly has even finished his trial. I've finished first trial, but it was mistrial. During the search, the police seized evidence used to prosecute case for a felony assault on an officer. Case moved to exclude the evidence under the Fourth Amendment and Montana's parallel protections. The case was convicted. Appealed to the Montana Supreme Court, which affirmed 4-3. Okay, here are the facts. On September 27th, 21, Case's ex-girlfriend called police dispatch and asserted that Case had threatened suicide during a telephone argument that evening. J.H. purportedly became concerned when Case said that he was going to get a note or something like that and threatened to harm any officers that came to his house if she called the police. J.H. claimed Case was threatening suicide and the phone just went silent and she didn't get a response. According to J.H., Case said he had a loaded gun and all I heard was clicking and I don't know, I thought I heard a pop at the end. I don't know. Gunshots don't sound like pops. 3 officers went to Case's home. Dave Heffernan, Richard Pasha, and Blake Lindstead. Those are great cop names. The officers did not consider obtaining a warrant because it wasn't a criminal thing and they were going in to assist him. Concerned with the danger to the officers, Captain Heffernan called Chief Bill Sather, who arrived about 30 minutes after the other officers. Pasha and Lindstead looked through the windows of Case's home. They did not see Case or observe any signs of distress, movement, or injury. Only empty beer cans, an empty handgun holster, and a notepad on the table. They knocked on the front door, yelled through a window, but he did not respond. As established by body cam footage, all the officers on the scene stated that it was unlikely Case required immediate aid, rather was likely lying in wait for them to commit suicide by cop. Okay, well that's telling. I mean, it seems like they objectively didn't believe. They like literally didn't suspect it. So it's not like reasonable suspicion. There's just no suspicion. Okay. They're not reasonable belief. There's just no belief, rather. The officers were familiar with Case's history of alcohol abuse, mental health issues. Critically, they were also aware of a prior encounter with Case that the police treated as an attempt to elicit a defensive response. I used suicide by cop. While outside Case's residence, Sergeant Pasha remarked to the other officers, "I'm scared that maybe he didn't actually shoot himself because he can't, and he's tried suicide by cop before, and he left us all this so we can go in the house and he's going to pull a gun on us." So yeah, this doesn't even seem like it's a probable cause thing. It seems like they just straight up don't believe that he needed emergency assistance. The officers waited roughly 40 to 45 minutes from arrival before entering. Captain Heffernan first returned to the station to retrieve a ballistic shield, and Sergeant Pasha and Lindstead retrieved their personal AR-15s. Which is also kind of telling, because if he needed assistance, you wouldn't need a ballistic shield and an AR-15. I mean, you might just as a precaution, but it sounds more like a raid than offering assistance. Aaron said, "I called my brother years ago. Cops got there at the same time as my other brother. The cops ended up just letting my brother break into my other brother's apartment through a window." Yeah. Sather decided to enter Case's home after discussing the other officer's observation and concern. Sergeant Pasha continued to worry that Case wanted to engage the officers to induce them to fire on him. Pasha remarked that he's going to make us come into this house and he's going to want to shoot it out, and so I want to be prepared. Sather replied, "He ain't got the guts." Yeah, it seems like there's just no belief that there's an emergency. The 4 officers entered Case's residence through the unlocked front door, announcing themselves and yelling the whole time. Clearing the first floor, the officers again noted the holster notepad. They went upstairs. As Pasha entered and began to sweep an upstairs bedroom, Case began opening a closet curtain. Closet curtain? Oh, nice. Yeah, it does seem like, allowing the family to assist can be helpful, for sure. Instead of, like, escalating. He opened a closet curtain. Sure what that is. Pasha purportedly saw a dark object near his waist and fired one shot, striking Case in the left arm and lower left abdomen. Lindstedt entered the room and began administering first aid to Case. After Captain Heffernan and Sather entered the room, Heffernan noticed and retrieved a handgun lying in a laundry basket near Case. Handgun was seized and Case was taken to the hospital. They charged Case with felony assault on a peace officer. Case thereafter filed a motion to suppress evidence obtained from the warrantless entry into and search of the home. Trial court entered an evidentiary hearing on the suppression motion. The 4 officers involved in the search and JH testified at the hearing. The trial court denied the motion to suppress. Oh, that makes sense, Aaron. You know, we can slice the bologna. We can slice the bologna as thin as we want about exigency versus emergency in different statutory definitions in different contexts, but police department got a call. That microanalysis here says yes for the purpose of whether or not there was an exigency when they went in, because they still didn't know, was he in there, was he dead, was he waiting for them, was he going to do the suicide by cop thing? You know what was going to happen. They had to be careful. But it was an exigent circumstance. They went into the house without a warrant. It's not render what came as a result of that inadmissible. I feel like this is going to be tricky because it seems like a factual determination. Like, I think the trial court is wrong. Like, this is clearly what... If you wait 45 minutes to go in, it's hard to say there's an emergency. But that's not something the Supreme Court's going to consider. Divided opinion. I don't need to go through this. Reasons for granting. The Montana Supreme Court's decision deepened a longstanding split over a question left open by Brigham City. Does the reasonable basis standard for the emergency aid exception require probable cause? That's still confusing to me, conceptually. Montana, 3 other states, and 3 federal circuits have all permitted police to enter a home on less than probable cause, a reasonable belief or suspicion that someone inside is in urgent need of help. Again, that's the thing. It seems like they didn't have any belief or suspicion. Which is tricky. In contrast, the dissenters here would have joined the 3 circuits in 2 states, requiring police to have probable cause that emergency exists. I already read that. I think we can probably get to the oral argument here. I don't think we can read through all of this in the response. Actually, let me take a look at... I'll pull up the response real quick just so we can... skim it to see if there's anything there. Here we go. Let's see if you guys can see this. Okay, here we go. Let's see. Fourth Amendment's warrant requirement safeguards privacy and security of individuals against arbitrary invasions, but its prescription against warrantless searches must give way to the sanctity of human life. A restrained Supreme Court judge was asking, what is probable cause? Yeah, it is funny. I think it's one of those things that, like, I can kind of understand the question. Because it's like one of those things where you hear it so often, you don't really think about it. Like it's such a basic thing that you don't really consider its meaning. It's interesting. So it seems like they're basically just arguing that there was an emergency. But again, I think this just comes down to the facts of the case. Like it's the officers didn't believe it. But okay. Get a sense of where everybody is. Case v. Montana. This is just audio, right? There's not going to be any. There's no video, I assume.
And I insist.
I really wish that they would have video of the Supreme Court at this point. I do understand why they didn't, but I think it's gotten to a point in time where it would make sense to have it. I'm sure they don't want to be taken taken out of context and clickbaited all the time, but it is what it is. They don't show up on film. That probably is what it is. Wait, I gotta switch my thing here. Here we go. Ooh, that doesn't look right. I don't know why I'm worried about formatting an image that is literally not going to matter at all.
And I insist probable cause is not the right standard, but it also doesn't defend the
Wait, what?
reasonable. And I insist probable cause is not the right standard, but it also doesn't.
I guess we're just going to jump in. This is on 1.25 speed. I think it's going to be okay, but let me know.
Defend the reasonable suspicion standard applied by the Montana Supreme Court below. Instead, Montana and the United States asked the court to adopt some other threshold that would permit officials, for the first time, to breach the sanctity of the home when they don't have permission, don't have a warrant, and don't even have facts leading to a fair probability that an emergency is actually taking place within the home. Their proposed reasonableness standard is so vague that not even the state and its amici can agree on what it means. And its open-ended balancing approach invites abuse and confusion, leaving police and first responders without the guidance they need and citizens without the security promised by the Fourth Amendment. The court should adhere to the textual and traditional standard of probable cause. I welcome the court's questions.
Do we normally use probable cause standard outside of the criminal context?
Your Honor, the court has applied probable cause in camera, for example, with respect to administrative warrants, and in other contexts as well. I would point to, for example, Wren, where the court applied it to civil vehicle infractions. And so the court has applied it in non-criminal contexts.
What is the objectively reasonable basis standard?
Your Honor, I think the objectively reasonable basis standard applied in Brigham City calls for and really contemplates, sort of lends itself to some standard of certainty. And our position is that that standard of certainty is probable cause, the traditional standard that the court has applied. Yes, Your Honor.
Well, I mean, I'm just asking what it means. Is there any difference between that and probable cause?
Your Honor, we think that the standard sounds in probable cause. The court didn't use those words in Brigham City, and it did not use those words in Fisher. But we do think that the standard echoes probable cause. I'd point, for example, to the language in Pringle, where the court said that the substance of all probable cause definitions is reasonable belief of guilt. And so while the court didn't use the word probable cause, we do think that there is an echo between the standard applied in Brigham City and the probable cause standard.
Okay, so it's just saying the objectively reasonable standard is probable cause, but they just didn't use those words. That's confusing.
I was just going to say, when we talk about probable cause, we use it as a shorthand. It's probable cause of what?
So, Mr. Chief Justice, here it would be probable cause that an occupant is seriously injured or imminently threatened with such injury. Ordinarily, it would be probable cause to think a crime is being committed, but here, as the government explained in its brief in Brigham City, the object might change. But the way that the standard applies and the level of certainty does not.
Why isn't it something like probable concern or reasonable concern? It seems to me that you're taking a totally different context and applying these things just because we're familiar with them and because authorities are involved. I mean, did they enter this home because they were concerned that, I forget the name of the individual, would harm himself? or was it because they wanted to arrest him for a particular criminal activity?
So, Your Honor, the dispatch call was for a wellness check. But I think to get to your original question, the court has applied that probable cause standard, even though the object of it might change in different contexts. For example, Wren, a civil vehicle infraction, that's not a crime, and the standard's still mapped onto it. And we think that it maps on to the emergency context quite well, because officers and first responders don't have complete information. They're just trying to assess whether there's an urgent emergency that is happening behind the front door, and probable cause would help them do that.
You'd say urgent emergency. I mean, let's just say it's a patrol or whatever, he looks in the window and there's somebody who seems to be in some distress. Now, is he supposed to say, I can't tell if, he has a pain, or if he's having a heart attack or whatever before, entering?
Mr. Chief.
What? I'm not with him on that one. That seems like that would be an obvious example of probable cause.
Justice,
or even just lying on the ground. Why is that person lying on the ground?
Well, the court said in
because people don't ordinarily lie on the ground if they're well and healthy, so that'd be probable cause, I think.
Fisher that you don't have to have ironclad proof that somebody is dying before you go in, but the standard is under the emergency aid exception as defined in Brigham City, seriously injured or imminently at risk of such injury. And so I do think the court has fixed the threshold, but it said you don't have to have ironclad proof, and that's consistent with probable cause because, of course, probable cause also does not require ironclad proof. What it requires is a fair probability or a substantial chance, and we think that strikes the right balance given the important and really fundamental interest in the sanctity of the home.
I think that's critical. If there wasn't probable cause, then there was nothing the police could do. They couldn't get a warrant either, right?
Your Honor, there is a civil warrant available in the state of Montana, but to answer your question, in these circumstances, given the risk, I think what Your Honor is asking is whether they could do it immediately, and it would not be easy to do that.
No, it's not a question of whether they could dispense with a warrant requirement. If there's no probable cause, then they can't get a warrant. It seems to me that if the police could not enter this house based on the facts that they knew, then I don't know when the police are ever going to be able to enter a house to prevent somebody from committing suicide. Your client's ex-girlfriend calls them, and she says that he's indicated he was going to kill himself.
Again, this is where the facts, like Supreme Court doesn't really deal with questions of fact, they just deal with the law. And again, like the issue is that the officers on the scene they didn't believe that he was going to kill himself, objectively.
He was going to get a note. She heard him racking the action on a handgun. Then she heard a popping sound. Then the line went dead. She was screaming on the phone. He didn't answer. They go to the house. They try knocking on the door and yelling. They get no response. They see empty beer cans. They spoke to a neighbor who said his vehicle was parked outside. They shone a flashlight.
His vehicle was parked outside of his house.
To the window, they saw his keys on the table alongside an empty holster and an apparent suicide note. I mean, what more did they need?
Justice Alito.
Again, they waited 45 minutes, so they explicitly didn't believe that there was a suicide threat.
So I think what's critical here is the officer's extensive knowledge of Mr. Case. That knowledge goes back decades as to a couple of the officers. Chief Sather testified that he'd known Mr. Case his whole life. Captain Heffernan also had known Mr. Case for a long period of time. But it's not just that. Officer Lindstedt had been present at a couple of the prior incidents that also involved threats of suicide and what was perceived by Officer Lindstedt as an effort to provoke a confrontation with police. That is pretty unusual to have that amount of knowledge about a specific person, and we submit that weighs against the inference.
What more would they need here? They need to be able to look through the window and see him with a gun pointed to his head, or they need to see a dead body on the floor? What more did they need?
Justice Alito, I think the question is really what you would take away if they didn't know and hadn't had such extensive experience with Mr. Case, an experience from which they drew the inference that he was unlikely to kill himself, that what he was likely to do instead was to provoke. Yes, Your Honor.
Well, I mean, you're saying that because he had threatened to kill himself before and he hadn't carried through, then there were no circumstances under which they could ever enter his house to prevent him from committing suicide if he threatened again. Is that your position?
Our position, Your Honor, is as assessed by the officers on...
This is ridiculous. These are ridiculous questions. They're unserious. It's like it's kind of a slippery slope fallacy.
...scene, based upon their prior experience with them, with Mr. Case, including, I would note, percipient witness.
Again, like they specifically did not believe that he had done the thing. And Alito's questions are like, well, how could you ever? It's just not the facts at hand.
Experience, they drew the inference that he was unlikely to shoot himself. And
but I
that
find your argument very odd, right? We're trying to think about a standard here, and I would think that the relevant criteria are the amount of information that the officers had,
yes,
and the threat to the individual, the actual nature of the emergency. And so in this very situation, I'm thinking the fact that they had a lot of information about Mr. Case actually hurts your cause, not helps you. I mean, I understand you want them to draw a different inference about it, but, this person had a long history of threatening suicide, whether it be by cop or whether it be on his own or whatever. We have a long conversation, detailed, specific with the girlfriend about circumstances that look like they're creating a pretty significant emergency. I would think this, kind of like what Justice Alito is suggesting, on our axis of information and threat or risk, this seems like it's pretty high.
Justice Jackson, I think that information led the officers on the scene, because there are deliberations that are captured on body cam. Those deliberations by officers with quite a lot of extensive experience with Mr. Case are powerful evidence that Mr. Case was unlikely to shoot himself.
Yeah, that's the tension here. I think that's the problem with this case is, no pun intended, is that the problem is it's the fact. The issue is the factual determination, which was made by the trial court, and the Supreme Court's not going to go back and redo the factual determination, because that's not what they do. Hey, Vanessa. She wants him to make a better argument. Yeah, I mean, it's just a difficult. The Supreme Court's in a difficult position here, because I think that the factual determination by the trial court was clearly wrong. But that's not something they're going to review. They're just going to take the facts as they're supposed to, the facts as they're presented.
Because they're talking about him provoking a confrontation with the police, and I would just
and again, they're trying to make a standard, what should the rule be in all cases, and he's making arguments based on this specific case. And the Supreme Court does, rules for every case, rather than deciding the specific case, if that makes sense. So drawing a general standard from the facts in this case is going to be difficult, because it is kind of a weird situation, weird facts.
Quote, for example, Police Chief Sathers says,
yep,
he ain't got the guts. This is probably the 10th time I've dealt with him doing this. Or Sergeant Pasha, who said...
See, this argument right now is about the facts of this specific case. It's not about the law. I think he's completely right. I think it's clearly correct. But, yeah, it's going to be tough for the Supreme Court. So the person refusing help, don't they need something to be able to take them? Yeah. Yeah, that's usually a warrant or something like that, depending on the state.
He's been suicidal forever.
Okay, well, setting aside this particular case, let me just try to understand the standard that you want us to apply.
Yeah, sure.
You say that it should be probable cause. I thought we already had the emergency aid exception requiring, quote unquote, an objectively reasonable belief that an emergency is occurring. And I didn't hear that in your recitation. You said you want it to be a fair probability or substantial chance. So can you just describe for us or explain why it would need to be a higher standard than objectively reasonable belief?
Is objectively reasonable belief? They just seem like they're not higher or lower. They're just different. 5150. Yeah, I can't. It'll differ from state to state, but there's probably different procedures depending on where you are. But there's something like that.
So, Your Honor, we think that the objectively reasonable belief standard really lends itself to some standard of certainty, and we think that the traditional probable cause standard is the appropriate formulation.
I see. So you're saying you only have an objectively reasonable belief, in your view, if you meet the threshold of probable cause.
Yes, Justice Jackson. And I would say that the fair probability language and substantial chance, that's all from Illinois v. Gates. Those are just principles associated with probable cause. And we think that they make a lot of sense in this context, as they do in the context of investigatory searches and seizures.
I wonder if this is just a labeling exercise, Mr. Rowley, at the end of the day, because when we're interpreting the Fourth Amendment, we often look at what the common law has been, was, what positive law. We don't always, but we often do. Katz is another thing, but Jardines tells us to look at the actual law. And one thing I'm struck by here is, a private person would have a good necessity defense to a trespass claim, always. historically it appears, from what I can tell, when it reasonably appears necessary to prevent serious harm to the occupant. And that's almost exactly what Brigham City says for officers. And officers can't have any fewer rights than a private citizen to enter a home to render assistance. Now, that doesn't give them a license to go rummage about the place for crimes, but it does give them a license to enter to render assistance. I would have thought, what's wrong with just saying Brigham City reflects traditional common law principles and officers treated the same as private citizens?
Justice Gorsuch, I have a few responses to that.
I bet you do.
That's a good question. Oh, hey, Nick, I didn't see you there. Again, I think that's the tension of this case, is between the facts of the specific case versus the general rules. Because again, the officers subjectively did not suspect, they did not have a reasonable suspicion. Like, they objectively didn't believe that there was a danger here. And that's kind of the fundamental unfairness of the case.
I think the first response is, when the court looks to common law examples, what it's asking about is what the authority of constables was at common law. And so I just point to Wilson, for example. The common law of search and seizure recognized a law enforcement officer's authority to break open the doors of a dwelling. So it's what was the constable's authority at common law?
But it doesn't. The constable doesn't have fewer rights than a private citizen.
We've
often said that.
Justice Gorsuch, when the court talks about that, about the ability of officers to do the same things that an ordinary person is doing, ordinarily it's talking about whether there's a search, whether the Fourth Amendment is even implicated.
Right, and that's another whole question, whether there's even a search here. But I'll take as given that there's a search for the person to render assistance, but not for other purposes. It's not a license to go rummaging about the place. It is a license perhaps to enter and search for the occupant who's facing a serious risk.
But the necessity defense was a broad-based common law tort defense, as my friend points out in
Okay, I can explain this real quick. The necessity defense is to trespass. Obviously, trespass is going on somebody else's property, infringing or entering onto the property of another. And necessity just means that you needed to go. You had a necessity of entering onto the property. That can come in different contexts. But that would be your defense in a civil case. So, like, if you were suing somebody for trespass and they said that I needed to go on your property, then that could be a defense, necessity defense. And so here they're saying the police necessarily need to enter the house. And so it would be tantamount to the necessity defense in a civil case. They're comparable, at least.
In the respondent's brief, it was applicable to private parties as well as constables. So it doesn't say anything specific about constable authority.
But even if it applied to both, and it didn't require the magic words probable cause, whatever they may or may not add.
Justice Gorsuch, even if it did, even if you were to consider the necessity defense as the controlling principle here, as the state has suggested, it would hardly help the state because it was, if anything, more stringent than the probable cause requirement or the Affray rule because you had to be right. So
no,
the United States cites the restatement.
Yes. Okay.
But at common law, you had to be right that the necessity actually
What's
obtained.
Your best authority for that?
I would point to the state's own cases. I would point to Rex. I would point to the Wakeham case. In general, at common law, you had to be correct. Now, there is this reasonableness gloss in the second restatement. I would note that the state hasn't pressed this argument. It hasn't suggested that there ought to be some generalized necessity defense that would be drawn from modern-day tort principles. The way this has come up in the briefs is, as you suggested, is by way of common law. Yeah. And again, I think that the relevant question is, what was the authority of constables? And they had all these specific rules that are set out in the treatises.
Thank you.
I thought the hesitation of the officers that you pointed out before showed care before rushing in and thoughtfulness by the officers. So why don't you look at it that way?
Your Honor, I think that the delay, there were deliberations that were quite extensive in it.
Again, this gets to the tension between the facts and the law. Again, like the officers, their hesitation was that they didn't think that there was an imminent danger. I think that's really the issue in this case.
Took them 40 minutes to go in, as the dissent in the decision below noted. That amount of time is inconsistent with the kind of urgency you would expect if what you thought was happening was somebody was either bleeding out or was about.
Well, if they, after deliberations, walk away and he commits suicide, I mean, what are you thinking then of the officers?
That would be unfortunate and tragic, but we are trying to strike a balance between.
And the officers need some clarity, I would think, in circumstances like this about what they can do and what they can't do. And it seems like they thought about it carefully and decided that the risk was sufficiently high, to Justice Jackson's point, and the harm that would occur was sufficiently substantial that they should go in. And by the way, they're going in at great risk to themselves.
Of course.
And This is not, as Justice Gorsuch is pretextually looking for a crime or going in for some other pretextual reason or going into, it's going in really to help someone.
A couple of responses.
That's true.
One, there were certainly two risks that were
Lawyers
possible.
always
There was the risk that he was going to shoot himself, and there was the risk that he would try to provoke a confrontation with the officers. JH, the ex-girlfriend, actually identifies both risks. In the initial call, she expresses concern that Mr. Case is going to shoot himself. When she arrives on the scene, because she comes to the scene,
Again, this is going to be a difficult argument to make. I think he's getting back to the same thing. He's arguing about the factual determination that the state court should have made. Yeah, I think he's completely right. But it's difficult to do this at the Supreme Court level.
Says that he also said that he was going to try to shoot it out with the officers, and that echoes what Officer Lindstedt says when he arrives on the scene. What he says shortly after arriving is, last time we were here, he said he was going to shoot it out with, and he mentions another officer and then later on he recounts another incident where Mr. Case tried to provoke a confrontation on his perception.
Sorry about that. On the articulation of the standard you want, do you have examples where under the current law officers would go in, but you think under your test they wouldn't and shouldn't and couldn't go in?
Well, Your Honor, I think the swatting example that we cite in our brief is a very real concern. It's a pretty commonplace concern where somebody calls, and under the United States theory, I think it's at page 22, where you would use the severity of the threat to ratchet down the level of certainty that's required. If somebody made a swatting call and said, well, there's a bomb inside the house, it's a pretty big bomb, I walked by the house and I'm worried that it's going to blow up the block, you wouldn't even need corroboration. You could just go in. And so we think that just requiring a fair probability or a substantial chance and some corroborative work, and I think in a lot of heartland scenarios, the police would have that. And would. Yes, Justice.
Please, I'm sorry. Did I cut you off?
Please.
One of the things that strikes me here is the term probable cause is not itself self-defining, and most of the way we know what probable cause is because we have a body of case law that talks about it, and it talks about it in an investigatory criminal context. And in this context, that way of figuring out whether there's probable cause just disappears because that's not the context we're in. So I guess I'm wondering whether then taking a term from a context which has a body of precedent that is pretty much irrelevant to this one, that seems like a bad idea. And maybe what we did in City of Brigham and in Fisher is exactly what we should have done. Is we just use a different language, and we don't try to grade that relative to probable cause. It's just sort of a different inquiry, but it does focus on what's important. Do you have to have an objectively reasonable basis for believing that somebody needs emergency help? And I guess what I'm saying is, maybe in those two cases we did the best thing possible, and we're not going to be able to do anything better.
So, Justice Kagan, the court's always been reluctant to adopt a third standard. I think in Montoya it said...
Well, we did adopt a third standard, or, a third standard. I mean, we used different words for this different context, and why not just leave it at that?
Because, Your Honor, it produced a lot of confusion in the lower courts, as we explained in our cert petition. You had a significant number of circuits and states that applied a lower standard akin to reasonable suspicion, like the Montana Supreme Court did here. You had other states that applied a probable cause standard. And we do think that given that this situation is so recurring and that...
But why not just say, this is a different context, our probable cause precedents are pretty much irrelevant and can't help us. We think we got the standard right. That doesn't mean reasonable suspicion. Reasonable suspicion is an entirely different thing. Go figure it out. Case by case, in the normal way that courts do.
Well, even the state doesn't defend reasonable suspicion at this point.
I know, and we would say it's not reasonable suspicion. It's just this. Do you have an objectively reasonable basis for believing that emergency help is required?
If the court were to reject a reasonable suspicion standard, we would be entitled to a remand even on that ground. But we do think that it would be better, that the better approach is to provide a little more guidance to officers and first responders. And while probable cause hasn't been applied by all courts, it actually has been applied by a significant number of the lower courts. In this specific context, the general principles that apply there when you're assessing probabilities, comparing the relative strengths of different sources and information, those map on pretty cleanly. And even if the court just drew on concepts like fair probability and substantial chance, that would actually be helpful. And it would be
fair probability and substantial chance, why are those any better than objectively reasonable basis? I feel as though we're just substituting, your terms for our terms. So these were our terms.
Again, I think this is getting to the tension between the facts versus law.
We used them twice, let's use them again.
Because reasonable basis to believe, we submit that it lends itself to some standard.
I think the trial court was wrong under any of these standards. Which is kind of the problem. I think the trial court just got it completely wrong.
certainty, but it doesn't spell it out. And for officers and first responders who are trying to figure out, it's pretty dangerous to go into
and like the Supreme Court can't change the rule just because the one trial court got it wrong. And that's kind of, I think, what they're grappling with implicitly.
a house as the common law sources recognize, as officers express concern about all the time. And so you need some level of certainty for officers and first responders to decide, look, we know enough, there's a substantial chance that somebody is seriously hurt behind that door, and so it makes sense to take the risk and go in. And we think that standard is certainly preferable to a reasonableness standard where you're balancing interests on the ground the way the state and the United States have suggested. If I might, I would just say that the court has always expressed concern about in reactive situations where officers are trying to make quick decisions about engaging in balancing. The court expressed concern about that in Dunaway.
I think Justice Barrett has a question.
Yes, Your Honor.
Oh.
Counsel, I think we're fighting about labels, and you got to the point, but you keep resisting it, okay? The court below did not use our Brigham City standard. It used a reasonable suspicion standard. I'm quoting from itself, from the decision below. Objective, specific, and articulable facts from which an experienced officer would suspect that a citizen is in need. Reasonable suspicion, as we've defined it, means a particularized and objective basis for suspecting the particular person stopped of criminal activity. So they use a standard akin to reasonable suspicion.
Yes, Justice Sotomayor.
So what you're saying is whatever standard we announce, we should vacate and remand to go back. And the question becomes, how is Brigham City different than probable cause other than in its subjective? I got two quotes, one quote from two of our cases that says, probable cause, quote, is a reasonable ground for belief of guilt. Our Brigham standard says, we're not talking about guilt here. Our Brigham standard says, objectively reasonable basis for believing, that's a reasonable ground, that an occupant is seriously injured or eminently threatened with injury. I don't know, Justice Kagan was right. This is, in my mind, simple. Apply the right standard and tell us what the objective facts were. Correct?
Yes, Your Honor. And certainly
for believing that the occupant was seriously injured or eminently threatened with such injury.
Yes, Your Honor, I would just say that formulation in Brigham City did generate a bit of confusion in the lower courts, even though we submit that it is consistent with and really resonates with probable cause.
Well, it doesn't resonate with reasonable suspicion.
It does not, and we would be entitled to a remand on that ground. But I want to make sure I get to Justice Barrett's question.
Thank you. I think it's very difficult because we talk about how much information the person has. I think it could be more pertinent in the situation with how little information they have. I mean, think about an officer who walks down the regular beat, and there's a picture when there is some person lying on the sofa that looks like he's, kind of an awkward position, and keeps going down, and 2 hours later comes back, it's the same thing. Mm-hmm. He knows nothing about it except that the guy appears perhaps to be dead or passed out or something. So he knocks on the door, he knocks on the window, and gets no response.
Yeah, again, I don't think that this is a good comparison because you can actually see the person, potentially in distress. There's a specific, yeah, true, Aaron. But I mean, that case is different from this case in that, here the officers, this kind of gets to Nick's point where they say some cops will find a reason after the fact. That's not even what happened here. It's even worse than that. The cops just didn't have the suspicion.
And then figures he's worried about it. He breaks the door down or picks a lock, and he walks in, and the person wakes up, and there's 3 kilos of whatever. Is that is it wrong that he did that out of legitimate concern? He didn't know that that's just Fred or whatever.
We know that subject.
I'm just trying to think. I would want
Fred with 3 kilos.
Would want a police officer in a situation who walks by and sees somebody in the community that seems something's wrong. He hasn't moved in 4 hours. It doesn't look like he's taking a nap. But, and then what happens? Then does he have sufficient basis to, justify the search that led to the illegal drugs? So he doesn't know anything. Maybe if he knew a little more, or maybe his regular habit is to go to the pub at night, and that's why I find it very difficult to articulate a standard. I don't think it can be based on a probability of something going awry, or because you do want police to be, on the lookout for things that might be dangerous, even if it's not crime or criminal.
Certainly, but the court has always said subjective intent. So you might well be concerned as an officer or a first responder or even an ordinary citizen that something's going wrong inside the house, but there could also be innocuous explanations, even in the scenario that you just sketched out, Mr. Chief Justice. In a lot of the scenarios that Justice Kavanaugh similarly sketched out in his concurrence in Cornelia, it could tack either way, but oftentimes in those scenarios, the report, especially if it's from a neighbor or from a relative, is going to have a lot of information about why it's uncharacteristic, why this is weird, and that is powerful information and can be linked up with corroborating evidence to support going in, and at least it guards against unnecessary and needlessly dangerous confrontations.
Justice Thomas? Justice Alito?
What is the substantive difference between the words that were used by the Montana Supreme Court and the words that we used in Brigham City?
So, Justice Alito, what they said was objective, specific, and articulable facts from which an experienced officer would suspect that a citizen is in need of help.
What's the difference between that and what we said in Brigham City?
Reasonable basis to believe that someone is seriously injured or imminently threatened with such injury is different because it doesn't use the word suspicion. And I think the dissent is right to say that the words used in the majority opinion below sound in Terry. Not just the use of the word suspicion, but even the specific and articulable facts. That's Terry-type language. In the footnote that accompanies that standard, the majority analogized and said it was comparable to the Ninth Circuit's exigent circumstances test, but the language is quite different, and it is not the Brigham City language that Justice Sotomayor quoted.
No, I had a couple more questions. I'm puzzled by your explanation of why the police did what they did. Why did they go in your view?
Why do I think subjectively? I think that they treated it as to be honest, as a community caretaking exercise.
They didn't think he was. They didn't think he. Put aside the fact that Fourth Amendment looks to objective facts, not to subjective. But your view is they didn't really think he was going to commit suicide. What he really wanted to do was to commit suicide. He wasn't going to kill himself directly. He wanted to commit suicide by police. So they said, well, all right, let's go in. So he will pull a gun on us, and then we will shoot him. And if that's what he wants, we're going to oblige him. I'm totally puzzled by your explanation of what you think really went on here.
Justice Alito, I think that risk is the risk that was focused on in the on-the-scene deliberations. I'll just quote, again, Sergeant Pasha. He's been suicidal forever, and he hasn't done it, but there have been several times when he's tried getting us to do it. Later on, Sergeant Pasha says, I'm scared that maybe he didn't actually shoot himself because he can't, and he's tried suicide by cop before, and he left us all this, so we're going to go into the house, and he's going to pull a gun on us. So there's a refrain.
So they wanted to oblige him in his desire to commit suicide by police and thereby expose themselves to serious risk of death or serious bodily injury. That's what was going on?
Your Honor, at a certain point in when you watch the video, they get sort of ahead of steam and they're starting to just prep to go in. And of course, they have to do some prep, but they are focused on taking the preparations that they'll need in case he wants to shoot it out with them. And that kind of momentum leads after 40 minutes to the entry. But again, if you consider the on-the-scene assessment by officers who knew Mr. Case and the risk that they thought was the serious one, it was the risk that he was going to provoke a confrontation. I mean, so
if we write an opinion and we set out the facts of this case and we say, well, it has to go back to the Montana Supreme Court for them to apply the Brigham City test, will it not be the case that those people who instruct police officers are going to say, wow, if the Supreme Court thinks that this is even a close case, it has to be sent back to the Montana Supreme Court. We don't know when you can ever go in and try to prevent somebody from committing suicide unless you literally see through the window the guy's got a gun to his head or they see a dead body on the floor. So look, let's do the safe thing. We're just not going in unless we've got absolutely ironclad proof.
Again, they subjectively didn't believe that he killed himself or that he'd done this. They waited 45 minutes. They actually didn't believe. That there's a danger here. And again, I get that is the struggle.
Justice Alito, three things. The court's already said in Fisher you don't need ironclad proof. The second thing is Of all the Supreme Court justices on the Montana Supreme Court, there was not a single justice who voted to uphold this search under a probable cause standard, and 3 justices said it did not meet probable cause. And the final thing, I again would go to the officer's own assessment. It is an unusual case because they had so much information about him, and it's not just that they knew him. One of the officers was a percipient witness, was there at 2 of the prior incidents.
Thank you. I get it.
Justice Sotomayor?
Counsel, that the state court is applying a lesser standard than reasonable suspicion. It cited the Lovegreen, its own precedent, Lovegreen.
Yes.
And in Lovegreen, it said it characterized community caretaking stops as the least intrusive category of stop, even less intrusive than a Terry stop. And that's the standard they're using.
That's right, Your Honor.
And that's not the standard we set in Brigham.
It is not. And
now, stop trying to help yourself. I've gotten the point out, right? All right. Let me get to the second point, which is Brigham also said the manner of entry has to be reasonable, okay? The one thing that nobody ever discussed here, including Justice Alito, is he does this when he's drunk.
Stop talking.
Correct?
Your Honor, the call was that he had been drinking.
And all of these calls to the police had been, nobody thought of just letting him ride out his drunkenness, did they?
No, Your Honor, there's a comment on the tape. I believe it's Officer Lynn.
I'm going to steal that phrase, ride out his drunkenness. Oh, I like that.
Said, who poses the question, do we leave him? But it is ambiguous as to what he's connoting.
All right. Now, they also didn't think of, instead of death by suicide, since he never pulled a gun on anybody else, okay, getting medical personnel to go in, which lots of divisions do on suicide cases, don't they?
They do, Your Honor. Here, I just would note that Officer Lindstedt still did ask, should we stage medical, but I don't think that they did that, and there was no further discussion.
That's the point.
Yeah.
They didn't try to call. They didn't do anything except not get a warrant and break it. Correct?
That's right, Your Honor. They talked about calling other people, my family members, the father. They talked about calling him. They ultimately, at least...
Yeah, James, I think that's definitely my takeaway from this. At least others know about fuckery. Like, again, it's difficult for the Supreme Court to make a general rule about this case because it's just a weird case. Not weird, it's not necessarily uncommon. But it's difficult in that the facts are suggest to me at least the trial court just made the wrong decision with respect to the facts. It's not like it would be a more interesting case if like the suicide by cop stuff had never happened before, and all they had was the girlfriend's call. That's all they had to go on. That would be a more interesting case for the Supreme Court to consider. But here, I think the tension is just that I've said this 1,000 times already, but that they just didn't believe that there was a danger.
On the body cam videos, there's no...
So there's a real question, even for the court below, whether the entry under the facts of this case...
Yeah, exactly.
Not generally when you're really afraid of a suicide, because they're saying he doesn't have the guts. It's not one officer. A bunch of them were taking... It sounded to me like they were taking bets on it, and everybody was saying, he wants suicide by cops, he's not going to shoot, he doesn't have the guts.
Right, Justice Sotomayor. I would quote the dissent. What the dissent says is all the officers on the scene stated that it was unlikely case required immediate aid, but rather was likely lying in wait for them to commit suicide by cop.
So they can decide, not us, on these facts, whether it meets the Brigham standard.
Yes, Your Honor.
What we do know is that the Montana court used a different standard, lower than reasonable suspicion.
That's right.
Thank you.
Justice Kagan? Justice Gorsuch? Justice Kavanaugh? Spirit?
One question, and maybe Montana can answer this or weigh in if you don't know. Would it be normal or best practices to send in just medical personnel when someone has cocked a gun over the phone and is known to be armed?
No, Your Honor. I believe in those circumstances, officers would be called to the scene.
Thanks.
Justice Jackson?
In those circumstances, would you think there was probable cause? Setting aside the quirky details of this case and all the stuff the officers knew, under your probable cause standard, if we just had the girlfriend...
Hey, this person's smart. I did not pre-listen to this. I just said this. I should be on the Supreme Court.
Justice Jackson?
In those circumstances, would you think there was probable cause? Setting aside the quirky details of this case and all the stuff the officers knew, under your probable cause standard, if we just had the girlfriend call and what they observed when they got to the scene?
If they actually, I want to be careful because if what they actually got was a call that said not a pop, but there was a gun, the action, as Justice Alito suggested, was engaged, and there was a...
Really, it has to be that detailed.
Well, I mean, a pop could be anything over the phone. I think it's different if there's slide action or you can hear the gun being engaged in some way.
Yes, I don't want to belabor this. I guess I'm just trying to isolate
Sure.
suicide by cop knowledge and find out whether, under your own test, all the stuff up to that point would count. And you're just saying we don't have probable cause because of the suicide by cop scenario.
Yes, Your Honor. It's all the information that is countervailing about the risk.
Thank
yes,
you.
Your Honor.
Thank you. Mr. Corrigan?
Yeah, I think
Mr. Chief Justice, and may it please the court. This court should affirm the judgment below for 3 reasons.
Yeah, it kind of seems like James said, it might be remanded just because maybe the right standard wasn't applied by the court, and they're not going to. It'll be a 1-page opinion. I could totally see that happening.
First, the Fourth Amendment protects against unreasonable searches, not all warrantless ones. The framers enshrine that tradition of reasonableness, not a rigid warrant rule, in the Fourth Amendment. At common law, officers and private citizens alike could enter the home as required by necessity when life was at risk. Petitioner's rule would turn that structure upside down. He asked this court to graft the warrant clause's probable cause requirement into the reasonableness clause itself. That move has no basis in text, no footing in history, and no support in this court's exigency precedents. Second, this court has already set the standard for emergency entries at objective reasonableness. To adopt petitioner's view, this court would have to overrule the holding in Brigham City v. Stewart, discard Michigan v. Fisher, and recast probable cause, the classic criminal law concept about belief of guilt, into something entirely new and applicable to non-criminal, non-investigatory emergencies. Third, the objective reasonableness standard provides sufficient guidance and flexibility for emergency aid cases. Conversely, a rule demanding probable cause of peril would force officers to stand outside a dying man's door, calculating legal thresholds instead of saving his life.
Fuck off. They already have a standard that they have to consider.
That's not what the framers wrote, and that's not what this court has ever required. The Montana Supreme Court applied the rule required by the Constitution.
Okay, I'm already annoyed by this guy. They're just ignoring the facts of the case, which, I mean, it is for the Supreme Court. They can kind of do that to some degree. But again, like, the officers didn't believe the stuff they were supposed to believe.
And this court's precedents. Officers may enter when they have an objectively reasonable basis to believe someone inside needs immediate aid. That standard is faithful to text, history, and common sense. I welcome the court's questions.
Did the Montana Supreme Court cite Brigham City?
It cited its own case law, and it relied on Cornelia, which relied on Brigham City. So,
yeah, I'm feeling a remand is probably likely based on that question.
There seems to be a disagreement between you and petitioner as to whether or not that standard was applied.
It applied the Brigham City standard. It applied the totality of the circumstances about whether officers had an objectively reasonable basis that someone inside needed immediate aid. And so it applied the words of Brigham City.
Isn't it our normal practice, though, if we're not certain about the standard and we state a new standard, that we send it back?
Yes, Your Honor, in some instances. But I think it's very clear what standard the Montana Supreme Court applied here. And the facts are particularly strong that whatever standard this court lays down, the facts here satisfy it, that the officers here had an objectively reasonable basis for believing Mr. Case needed immediate aid.
Would it be helpful, do you think, to clarify? I mean, there's some ambiguity about what the standard was that was applied. So we don't care about that, okay? It's what we said in Brigham City. And then apply that standard to these facts. We don't have to. We could send it back. But would it help to provide guidance to confused lower courts for us to use a concrete set of facts to explain what that means?
Absolutely, Justice Gorsuch. This is a scenario that officers face every day. Emergency aid scenarios are very common, whether it's a suicide call, like in this case, a call of an elderly individual who's missing, or a hybrid scenario like Brigham City or Fisher. Having this court apply whatever the Brigham City standard to the facts in this case would be very helpful.
And we have a full enough record to do that, you think?
Absolutely.
All right. And what do you say to your friend on the other side about the necessity defense being more liberal under the restatement than it was at common law?
I think at common law, my friend on the other side pointed to the cases of Rex v. Cody and Scott v. Wakeham. When you read those cases, it's all based on a reasonableness analysis. In the Rex v. Cody case, the restraining was justified if it had been proved to have been with the best motives or necessity was manifestly proven. To me, that sounds like a reasonableness standard. Now, some of the issue in terms of what the reasonableness standard at the time is that in tort law, we don't get the full reasonableness standard until 1837 in the Vaughan case in England. But Cook is writing in the 16th century about applying the law of reason to the reasonableness of the common law. And so implicit in jury and judicial verdicts at the time, the concept of the ordinary person and reasonableness is baked into the...
Okay, I got the exact languages. Oh, hey, true crime. Let me see. The standard is police may enter a home without a warrant when they have an objectively reasonable basis for believing that an occupant is seriously injured or imminently threatened with such injury.
the common law in England and the common law here, and of course textually in the Fourth Amendment.
Does Montana follow the restatement?
We follow the second restatement, Your Honor.
Counsel, we're talking about this as an emergency situation, but there's a lot going on that doesn't look like an emergency, right? I mean, they get there, they're walking around for a while, then they get the boss to come down. I mean, they call for somebody else, and they're still there, and then they go get a body shield. I mean, it doesn't have the atmosphere of, we've got to get in there right away. And I wonder if that detracts from the idea that they had sufficient justification. And particularly since, at least as it said, that the emergency would come in if the officers came in, and then you'd have the question of suicide by police.
Yeah. Well, Mr. Chief Justice, I would certainly agree that at some point, if they did wait too long, that would cut against an emergency. But in this case, I think the timeline.
What? Okay, I can't wait to see where this is going. YP says this guy was only injured inside his head, so does that count if you can't see the injury? Yeah, no, I mean, I worried about all the pet. Yeah, that's you. This is a weird case in a way, in that like there seems to not have been an emergency, but it's a case about the emergency standard when it seems like there wasn't really an emergency, which is a tricky position for the court to be in, and that's kind of what this question is getting at.
You'd have the question of suicide by police.
Well, Mr. Chief Justice, I would certainly agree that at some point, if they did wait too long, that would cut against an emergency. But in this case, I think the timeline is very important. Officers arrive on the scene at 9:14 p.m. His ex-girlfriend arrives at 9:18. They do a knock and announce. They knock several times, and they spend the next 20 minutes trying to verify the facts that she communicated to them in this case. And it's at 9:34 p.m. that, as they're doing the search of the outside of the house, that they identify the suicide note when they flash their flashlights through the window. And so they spend about 20 minutes trying to verify the facts that were communicated to them. And I do think, though, that the possibility of suicide by cop counseled additional caution on their part. And you see this on the body cam. Of course, they are worried about the concept about the instance of suicide by cop, but that's why they're doing the additional investigation of walking around the outside of the house, yelling into an open window, giving Mr. Case every opportunity to let them know that he is alive and inside, which he didn't do.
General does Montana have, I mean, it seems to me that there's some confusion in the case law, and I mean, I think there was some sloppiness in the standard in this.
Was the note in the window? I think they just saw a notepad, like on a table inside.
Case. Does Montana have some separate community caretaker exception or something that it calls a community caretaker exception that's really equivalent to our emergency aid section from Brigham City?
Yes, Justice Barrett. I think that's when the Montana Supreme Court discusses the community caretaking exception, I think they're folding in Brigham City. There was some confusion, I agree, in the standard, but it's an exigent circumstance.
Okay, that seems like the case. That seems like a remand right there, like he just admitted to it. Courts love not deciding things when they have the opportunity and remanding. And he just said there was confusion on the standard.
I think that's when the Montana Supreme Court discusses the community caretaking exception, I think they're folding in Brigham City. There was some confusion, I agree, in the standard, but it's an exigent circumstance exception to save human life. And I think that's essentially what they did.
Okay, I mean, they're free to call it, as a matter of state law, I guess, whatever they want to call it, but you would agree that there is no such strand, that we've rejected that. We've rejected it in Cornelia. It's been a long day. But that the emergency aid exception and the standard from Brigham City is all you're asking for, and you're not saying that there's some yet another looser standard.
That's correct. We are entirely consistent with Brigham City and Caniglia. We're not asking for anything beyond that.
And their citation to Loveland we just ignore, where they said it was less than reasonable suspicion?
Well, the court is admittedly using imprecise language. What I think is what's important is that the court is applying the totality of the circumstances, and it's making sure the scope and manner of the search is reasonable. And of course, as my friend was up here and the court was asking questions, pointed out that the court does use some language mirroring at times in sort of the more specific application of the test that mirrors reasonable suspicion. But this court has done that in TLO and the special needs cases. And so what the court is looking to do is make sure that the scope and manner of the search are reasonable and balancing the privacy interest at stake.
I actually don't see any them addressing the reasonableness of the manner in which this occurred. And I pointed to things. Justice Barrett was right. You're not going to send medical personnel into a room with an armed person, but you do call medical personnel to make calls or to talk to someone who's suicidal on the phone.
And if they thought that he had shot himself, why wouldn't they have called the ambulance immediately? If there was an emergency, even if they don't go in, even if the police go in first, you would still call an ambulance just to be there and to treat after the police resolve the situation. Court should use precise language. I agree. The more I hear from this, the more it sounds like it's going to be a remand. And it seems like the court generally believes that I don't know. I'd have to go back and re-listen to the numbers of people asked, the questions they asked. It's hard to tell. Seems like they generally think it was reasonable, but they'll probably remand to have the state Supreme Court reconsider.
It happens quite often.
Standard.
They could do that. Now,
you could put a megaphone out there.
I will point out the time exigency here is that they did call medical personnel when case.
Stop. It's 45 minutes.
After the entry and he had been shot, but the officers here.
That's irrelevant. No, that's a completely separate thing. Calling an ambulance after you shot him is different from calling an ambulance because you think he shot himself. Those are two incredibly different things. Come on, bro.
They could do that. Now,
you could put a megaphone out there.
I will point out the time exigency here is that they did call medical personnel when case after the entry and he had been shot, but the officers here.
Yes, after he had been shot. When they had a great probability of knowing that he was seeking the suicide by cop.
There's no indication that
oh, that was low-key roasting. I loved it.
That EMTs would be able to talk down Mr. Case. In fact, Chief Sather, who had known Case for 30 years, testified that based on prior incidents, he actually thought that he could talk Case down and get him out of the house. It was only after they received the reliable indicia.
So they didn't believe. So you're using the fact that Sather didn't believe that he had. Okay.
Case had actually suffered a gunshot wound that the chief arrives and says, we have to go in.
Am I right, just to go back to where you ended with Justice?
Man, this guy, he had a 3-1 lead, and I feel like he's throwing right now. Oh, man.
Barrett, that you're not equating the City of Brigham standard with our Terry stop standard.
Correct.
You think that those are two different things?
I think they're two different things.
Okay. And as to the difference between the City of Brigham standard and the probable cause standard, is your position that the City of Brigham standard is laxer, or is your position that it's just different?
I think it's more flexible. And I think it answers a different question. So as the court recognized when my friend was up here earlier, it's probable cause isn't just about reaching a specific threshold. It's fixed to criminality. But objective reasonableness says, given the totality of the circumstances, would an officer taking a specific action be reasonable? And I think one way to think of it might be probable cause is a single determination about whether a quantum of proof has been satisfied. But objective reasonableness, as in this case, can be a progressive analysis. And what I mean by that is when officers.
So it would help me, I think, because that's a lot of words. And like, what's the case in the gap between the two? Like, what is it where a police officer would not have probable cause but can satisfy the Brigham City standard? What are the kinds of things you're talking about?
So I think if you take this particular case and subtract perhaps Mr. Case's history, which I actually think supports the officer's reasonable determination, or if they had not obtained the other reliable indicia. So if Case's ex-girlfriend had called him, she had heard the cocking of the gun, heard what she thought to be a gunshot, police arrive, they knock on the door, they don't receive any response. But they hadn't been able to see the suicide note, which might have been upstairs with him. They hadn't seen the beer cans or the empty paddle holster. I think that's a much closer call, but we think that's still objectively reasonable. And I would point out that our friends on the other side believe that even the very strong facts in this case don't satisfy probable cause. And so I think if the court, to Justice Alito's questioning earlier, if the court were to determine that the facts in this case do not satisfy probable cause, that is going to have very detrimental effects down the road for law enforcement.
No.
They say they don't.
Again, they really don't, because the cops didn't believe it was an emergency. So it's not. I have a cousin in Montana who lives at the end of a 10-mile private unpaved road, somewhat off-grid. Ask if he wants a roommate.
Satisfy probable cause because they're reducing.
Was the girlfriend in the room seeing the guy? Yeah, no. I don't know. Yeah, ex-girlfriend.
That was my question to him at the end, which is, without the suicide by cop information, do you think we get there? I thought he suggested we did, but it was the fact that the cops also had this additional information that made it less likely or objectively.
Again, we're getting back circling the drain again. Like, the cops literally didn't believe it was an emergency. They literally did not believe it. So, like, it's just a bad case to determine, like, reasonable belief, because they, like, objectively didn't believe it was an emergency. It's such a weird case. Like, it's clearly unjust and unfair, but like, it's just a strange case.
less likely that Mr. Case would actually commit suicide.
Well, I think it's important to put the suicide by cop in context. So some of what's happening at the scene, I think, is cop talk of Sergeant Pasha is clearly very concerned about suicide by cop.
What is cop talk? What now?
Commit suicide.
Well, I think it's important to put the suicide by cop in context. So some of what's happening at the scene, I think, is cop talk of Sergeant Pasha is clearly very concerned about suicide by cop. The context of suicide by cop first came up when Case was on the phone with his ex-girlfriend, and he says, "I'm going to kill myself," and she responds, "Well, if you threaten that, I'm going to have to call the police." And she says, he says, "I'll shoot it out with them." Chief Sather
That doesn't help you at all.
Responds to Sergeant Pasha's concern about that comment by saying he doesn't have the guts. So I think the dissent is incorrect at the Montana Supreme Court to say all the officers believed. And our point is certainly suicide by...
Yeah, but if the chief said he doesn't have the guts, he didn't say he's already done it. He doesn't have the guts implies that he's going to be consciously making a decision about whether to shoot it out with the police. And it's going to come down to whether he does or does not have the guts. So, like, that also doesn't help you. It's different, sure. Like, it's a different thing than, like, you know, whether it's suicide by cop or not. But, like, that also, like, means that there wasn't an emergency because he's conscious and awake and deciding stuff. Like, that doesn't help his argument at all. I was going to say, if that is definitely his plan, then wouldn't the cop entering the home just make it worse? Yeah, gaslighting future judges. It's an opinion, not a fact. Yeah. I mean, it seems like the chief also agrees it's not an emergency, even if it's for a different reason.
Cop was a possibility, but that was, I think, the officers ruled that out based on his escalating history of violence going back to 2015 and the incident that was 18 months earlier. And particularly once they found the note, Chief Sather is convinced that he actually has hurt himself this time. In terms of the test of reasonableness, we admit that objective reasonableness is an easy test, but it may not be an easy rubric to always apply, where the court is taking the privacy interest versus the nature of the exigency. But I think the court just did this in Barnes. And the court admitted that it's a fact-bound morass that demands careful attention to the facts and circumstances, including the facts and circumstances leading up to the climactic moment. And the court has to consider all relevant circumstances. And I think that the excessive force context makes a lot of sense here when we're talking about, at its apex in this context, the sanctity of human life versus the sanctity of the home. And the excessive force context also involves two strong competing interests of the safety of the officer versus the use of deadly force. And the logic of Barnes makes sense here. The application of it makes sense. And in terms of Brigham City, in terms of hybrid scenarios that have been brought up, I think that Brigham City and other cases that involve underlying criminal activity recognize, though, that first responders are first responders first. When they arrive on the scene of an emergency, they're not necessarily concerned about underlying crime. Their first instance when they respond to someone yelling help is to provide an aid to someone in need. They can worry about arresting someone for a crime or other criminal activity later on. We treat hybrid cases the same as all other exigencies. And what's important to remember is, as I was articulating to Justice Kagan, is the objective reasonableness standard allows a progressive analysis. And so when the officers arrive and do a knock and announce, it may not be objectively reasonable right away for them to go through the front door, but it allows them to go around the curtilage, to yell through an open window, to take progressive steps to alert the individual and give them every opportunity to respond and let them know that they are okay. And I don't think that probable cause allows that sufficient flexibility and doesn't differentiate between going through a door and breaking down a window. Whereas the Barnes standard and the reasonableness standard differentiates between the facts that make it reasonable to handcuff a suspect versus to tackle a suspect or to use deadly force. And that's why we think that the Montana Supreme Court appropriately applied this court's test in Brigham City. This court meant what it said in Brigham City, meant what it said in Fisher, that officers may enter when they have an objectively reasonable basis to believe someone inside is in need of immediate aid.
Thank you, Counsel. Justice Thomas? Justice Alito?
I think so.
Counsel, our entry into the home cases, and it's been paramount that a person's home, we don't enter without a warrant except in recognized exceptions. And I understand the instinct that says that we don't want someone in real need not to have the police enter quickly, but we're always balancing interests, aren't we? And not requiring enough proof also costs lives. Petitioner cites reports that people with serious mental illness are 16 times more likely to be killed by police during a police encounter. An investigation found at least 178 cases in a 2-year period where calls for help, not a crime, like a 911 call or a wellness check, resulted in the police shooting and killing the people they were called on to assist.
Weird.
It's a fine balance, but shouldn't we make sure that the courts below are at least following the right standard?
So
you keep telling us that this state is, despite using words that sound very similar to reasonable suspicion, despite a case, Lovegren, that says it's less than a Terry stop. I mean, there's some value in clarifying what we have said the standard is. If you're asking us to describe what the quantum of proof, sounds like you wanted us to accept what the Solicitor General is saying. Some possibility is enough. But that's never been the standard. It's a reasonable belief, not a probable belief.
So I agree that clarification from the court, and I think the court can clarify that it meant what it said in Brigham City, it meant what it said in Fisher, and that an objectively reasonable basis is what it is.
And it's not reasonable suspicion.
It's not necessarily reasonable suspicion. I think in some
there's
cases,
the qualifier.
It's in some cases the standard can look like reasonable suspicion, and in some cases the flexibility makes it look more like probable cause. But there's where we're getting to the degree of certainty of the exigency. It takes it.
You want it to be reasonable suspicion.
Well, the objective reasonableness standard is the most faithful to the text, history, and tradition of the Constitution. If given a binary choice, we would take reasonable suspicion over probable cause. But objective reasonableness is much more flexible and faithful to the text, and it accounts for situations like this one or others where there is some doubt as to whether an individual is in need.
So we might as well just say what the court below said. It's less than a Terry stop.
Well, I think I'd look to the language in Fisher where the court says officers, of course, are going to have less than perfect information, but that doesn't mean they should walk away from potentially dangerous situations. And all we're asking is that they...
Again, I don't think that's the case here. I don't think they had less than perfect information. I think they had enough information to determine that they shouldn't go in without a warrant. In their own words, I'm not even blaming the cops. I don't think they misevaluated. I think the problem is that they evaluated correctly.
Use their common sense. Officers, as well as reviewing courts, are more than capable of figuring out when the facts don't add up and when an objectively reasonable belief doesn't exist. And I think I'd go back to this court could apply whatever standard it articulates to the facts in this case to provide ample guidance to lower courts.
Justice Kagan?
I think I'm confused, General, because I thought you told me that the City of Brigham standard is not the same as the Terry stop standard and that you were not asking for the latter.
It's not. It's not in all cases. The Brigham City standard is the Brigham City standard. In terms of the degree of certainty, it can vacillate between probable cause and reasonable suspicion. Okay. The text is just more complex than that.
Thank you.
Ms. Gorsuch, Ms. Campbell, Justice Barrett?
You might be better off just sticking with Brigham City. I think what you're saying is that in some circumstances, applying reasonable suspicion or objective reasonableness in the Brigham City sense might yield the same result. Just like sometimes applying Brigham City and probable cause, whatever it might mean in this context, might yield the same result. But are you really saying that we should do something different than in Brigham City or muddy the waters by saying, objectively reasonable basis, but could be reasonable suspicion?
You're correct on
that. Yeah, this is sounding like remand to me.
On the first part, on the former, we are not saying that that Brigham City means reasonable suspicion. What we're saying is, in some instances, it could, as you said, Justice Barrett, yield a result like reasonable suspicion, just like it could yield a result like probable.
But we don't need to say that. I think that would be confusing. I think we could just say Brigham City, objectively reasonable basis to believe, and put a period on that.
I agree, Justice Barrett.
Okay, thanks.
Yes, Jackson.
Yeah,
thank you, counsel.
This kind of sounds like Barrett's on the defendant's side, on case's side, based on those questions, at least as far as remand goes. This seems like a simple disposition based on these questions. Just remand it, tell them to reconsider. And the court could very well decide on remand for the same outcome, unfortunately.
Mr. Kobe?
Mr. Chief Justice, and may it please the court. This court should adhere to the objective reasonableness standard for emergency aid entries set out in Brigham City, rather than require what petitioner calls probable cause of a danger. Petitioner's theory has no basis in the Fourth Amendment's text, which links probable cause to warrants, not to searches in general. History doesn't support petitioner's theory either. The framers adopted the Fourth Amendment to guard against overzealous criminal investigation, not to hamstring officers from providing life-saving aid to people in need. Yet petitioner's rule would make it harder for government officials to help people in crisis, from victims of domestic violence to older people who have...
This has nothing to do... No, stop. Again, they subjectively did not believe that there was emergency, the emergency that they're now claiming existed. This has nothing to do with belief because they didn't believe it.
Fallen and can't get up. This court should instead reaffirm that emergency aid entries are assessed for reasonableness, a flexible determination that accounts for both the severity of a danger and its likelihood. States are always free to craft their own rules above that constitutional floor, but the Fourth Amendment does not categorically require probable cause of a danger for an emergency entry. I welcome the court's questions.
Should we apply this rule here or send it back?
We think you should apply this rule here. I think there has been some question about the Montana Supreme Court's use of the word suspect in its test, but I would urge this court not to read a decision like a statute, especially because elsewhere in the decision, the Montana Supreme Court said that its test largely mirrored the Ninth Circuit's test, which uses the objectively reasonable basis.
Yeah, it's just saying you can set a, like the federal constitution sets like minimum standards for rights, but states can go above that and give you more rights than the U.S. Constitution.
For believing language, and because it used other verbs elsewhere besides suspect. I think PEDAP 14A footnote 5, they say there was an objectively reasonable
So it's using a bunch of different verbs that aren't the right ones. That's a good argument.
basis for finding a danger. So I would avoid sending it back just on the basis of that word suspect or a citation to Lovegren.
Don't use an overly technical reading.
When they addressed the dissent's accusation that they were using reasonable suspicion, nowhere did they say, we're not. Would have been the easiest thing to do. We're not using reasonable suspicion. Instead, they said, we don't have to.
Yeah, I think she might have misspoken, Trenton, but I assume that's what she meant.
Because it's more, it's a different purpose than an arrest. It seems to me that that's not a disavow.
I do read them to sort of disavow that they're applying a reasonable suspicion standard.
No, they said we're not giving open license, but they didn't disavow it.
I think even if you disagree with me about that, the reason not to send it back is the one that Justice Alito articulated earlier, which is if you give sort of officers and lower courts the impression that there is any doubt about whether the facts here satisfy the Brigham City test, I think that's going to lead to a lot of confusion and a lot of concern that officers can't make entries based on the type of information that they would think they could.
If we apply it here, are we ignoring the countervailing factors of why they shouldn't have gone in? We have a number of officers on tape saying he has no guts, he won't kill himself. We have others officers saying he's waiting for suicide by cops. There's no attention paid by the officers to trying the father or to calling a doctor to call out to him, not go into the place. All they decide to do is go in. Are we then inviting a carte blanche to say, don't think of more reasonable way or manner to enter?
I don't think so, Justice Sotomayor. I'd point to a couple things. One, I'd avoid relying too much on the cop talk that's on the tape, especially because in the record in the JA at the suppression hearing, several
Is
of the
that different from just speaking? That's the second time I've heard that phrase. What is cop talk? I mean, I could make a joke right now, but I'm not going to because I'm on video. But what does that mean? It's just speaking. Like, it's just their words. What is cop talk? Oh, don't listen to what they said. They're not serious people. Like, what? Like, I'm not even I'm like respecting the cops here. I'm the one being respectful. They're being like, oh, cops are idiots. Don't listen to what they say. Like, they're grown-ups. Like, it's perfectly fine to listen to what they say. What are you talking about? Don't listen to the words that they said.
I don't think so, Justice Sotomayor. I'd point to a couple things. One, I'd avoid relying too much on the cop talk that's on the tape, especially because in the record in the JA at the suppression hearing, several of the officers did testify, sworn testimony, that they were subjectively afraid that he had in fact injured himself. So this was a situation.
Did they give a basis for that?
I think the call and the suicide note and the empty holster. So I think this is a situation in which there were risks of multiple outcomes, and the fact that they articulated a concern about one of those outcomes doesn't mean there wasn't also an objectively reasonable basis for believing that the other outcome might have happened as well.
So I take it that you agree with Montana that the degree of certainty can vacillate under the Brigham City test, and that's really the work of your sliding scale. Is that right?
I think that's right. What I would say is it's not so much like in one case you need probable cause and in another case you need reasonable suspicion. Our point is just that there is not a fixed prescribed quantum of certainty of danger that needs to apply in all cases. The amount of information, the reliability of information, the corroboration of information that an officer would need to make their entry reliable in one instance may not be the same as in another.
But those are the key factors. Would it be helpful for us to kind of say that kind of thing? In other words, I understood your sliding scale to have a matrix essentially that related to the severity and the amount of information.
I think so. To be clear, I think the sliding scale, it's just a metaphor. We don't mean it's sort of strictly formulaic or a matrix or anything like that. Just that these are relevant considerations.
Yeah, where is that from? I can't remember. I remember reading that. I distinctly remember that phrase, but I can't remember where it's from. Isn't that when body-worn camera is turned off and they brainstorm? Yeah, seriously. I actually have a case right now. This is a Georgia case where the cop literally just takes off his camera and leaves it on the seat of his cruiser, then goes and he goes and has a discussion with another cop off camera.
That can make an entry reasonable.
Yeah, I don't understand the sliding scale thing at all, I'll be honest, so help me out. I understand lots of different facts can lead to an objectively reasonable basis, okay? And it's almost impossible to catalog them all. But on the other end, on the severity, we said in Brigham Young what we meant, Brigham City, sorry. I am tired. That it has to be a severe risk of harm to the occupant. I'm paraphrasing, but life or limb is the classic formulation in Blackstone. That's the severity is the severity. It doesn't. There's no sliding scale. You don't get to go in with lots of evidence to deal with a hangnail.
I absolutely agree with that. There's I think what we would think of with the sliding scale, there's an outer bound on the sliding scale formed by Brigham City's use of that serious injury. But not all serious injuries are alike, and our point is that based on sort of the degree of the exigency, the severity of the injury being complained about, it may be reasonable in some instances for officers to rely on less information or less reliable information, and in other instances, it may be reasonable. It may not be reasonable to rely on so little information. So that's
do you have any thoughts about the common law of necessity?
Yeah, I think our point is that that's a useful guidepost here for the reasons that Your Honor articulated. The fact that private individuals were able to enter when life and limb were at stake, we think provides some helpful guidance about what the framers would have thought was reasonable here. I don't think that we think of it as a direct one-to-one analog, but I don't really think it's our burden to come up with a direct one-to-one historical analog here, given that we have the text of the amendment on our side. And it's really petitioner who's asking to graft onto the Fourth Amendment's reasonableness standard this uniform probable cause requirement that is not compelled by the text of the amendment itself.
Would you object to the court specifically saying that the officers have to have more than reasonable suspicion that an emergency is occurring?
I think we would object to it for a couple of reasons. I mean, one, I think because reasonable suspicion is a standard from the criminal law, just as probable cause is, for the reasons that Justice Kagan was just articulating with my friend, just pegging it to any one of these criminal investigation standards, I think, does more harm than good.
But why isn't that familiar? I mean, they're used to those standards. And so I appreciate that they do it in the criminal context when they're looking for crimes, but they understand, I would think, the difference between probable cause and reason, and I'm more focused on reasonable suspicion in that context. And so why couldn't we just say you have to have more than reasonable suspicion that an emergency is occurring?
Well, 2 points. First of all, police officers may be familiar with reasonable suspicion, but your standard here will also apply to firefighters, paramedics, all of whom may have no more familiarity with reasonable suspicion than with probable cause. And reasonableness is, I think, an easier standard to understand. Second of all, I do think, just given how varied emergencies are, it's best not to sort of set a floor at reasonable suspicion, just because this court can't really predict all of the manner of emergencies that could arise. And rather than hamstringing courts or officers with setting a floor on this, better to just stick with the objectively reasonable basis test from Brigham City.
Thank you.
Justice Alito?
In Brigham City, I'm quoting from the SG's brief. One way to...
Yeah, I trust firefighters. I trust their judgment. I'm fine with whatever they want to do.
conceptualize the emergency aid situation is that the basic requirement that the police have an objectively reasonable belief, i.e. probable cause, does not change. But the object of the probable cause does change. Rather than requiring an objectively reasonable basis for an officer to believe a crime has been or is about to occur, the officer needs an objectively reasonable basis to believe that an emergency need for assistance exists. Have you changed your position?
Yes, after the court's decision in Brigham City, which used the objectively reasonable basis language but did not draw that connection to probable cause that we had sort of floated in a footnote, we did rethink that. And in Cornelia, our brief 5 years ago, we made clear that our view is that probable cause is not the correct standard.
May not be, but Brigham is.
Yes, Brigham City is the correct standard, and we sort of disavow that equivalence. That
and reasonable suspicion is not.
Not the correct standard either. Objectively reasonable basis, just from Brigham City, is the correct standard.
Mrs. King, Gorsuch, Mr. Kemp, Mrs. Barrett, Justice Jackson. Thank you, counsel. Rebuttal, Mr. Rowley.
Thank you, Mr. Chief Justice. I think it's critical to remember that what we're dealing with here is an entry into the home, and there are these default constitutional rules that are decades and decades old. As the court has repeatedly said, at the very core of the amendment stands the right of a man to retreat into his home and there be free from unreasonable government intrusions. In Payton, the court said that the Fourth Amendment has drawn a firm line at the entrance to the house. And so these rules do not require, if you apply probable cause standards, some kind of fundamental tweaking of Fourth Amendment jurisprudence. We think that they are a natural application of these basic Fourth Amendment principles. I would also stress that in a lot of these situations where the emergency aid exception arises, you have not just potential safety implications, but also criminal implications. Think of domestic violence situations or the situation that the officers faced here. And so having a parallel standard of probable cause to think a crime is being committed, but also probable cause to think that somebody is seriously injured or imminently threatened with such injury makes good sense. Conversely, if you adopted a standard that was a sliding scale, as the government has suggested, or a lower standard for the emergency aid exception, there is the potential for abuse. You could backdoor your way.
Yeah, I agree with them. Like, practically speaking, I think it makes sense. I mean, just setting aside everything else, it does kind of make sense just to have the same standard in both cases. Probable cause for somebody needs assistance, probable cause for crime.
Into a criminal investigation. I just note that while the state now has expressed concern about applying a probable cause standard, in its brief in opposition, it noted that that a significant number of lower courts apply a probable cause standard, and they say it's functionally a probable cause standard, even if what they say in terms of the standard or the words used is different. And the court didn't suggest that that was a problem or that stopped police officers and other first responders from going in and helping with an emergency. And so we don't think that applying a probable cause standard, which is the default standard, would prevent officers from stopping or intervening in an emergency. On the common law, because Justice Gorsuch asked about that, I just note that the cases that my friend features in the respondent's brief, best cases presumably, do say that the defendant or the potential tortfeasor has to be right. In Scott v. Wakeham, the court says, and I quote, "The question was not whether the defendant sincerely believed he was right, but whether he was so." So this reasonableness clause is a restatement clause. I think the more fundamental point, though, is that when you are asking about constable authority, the focus is what the rules that governed constable power and what they could do are the cognate rules. And the closest one is the affray rule. It actually applies to the same set of circumstances that were at issue in Fisher and in Brigham City. Both of those involved what I think the court called a melee or a fracas that is essentially an affray. And we know what the common law thought about that. What the common law thought was that the constable had to see or hear the affray if he wanted to break down doors and part the affray. That standard is fundamentally inconsistent with a standard below probable cause. The necessity defense and none of the other specific rules that the state and the United States outline supports a standard below probable cause. And so we think that the common law is more supportive of our position than theirs, and that it echoes not just the language in Brigham City, but it also underscores other exigent circumstances cases like Minnesota v. Olson, where the court has said that probable cause for an exigency is essentially the correct or the proper legal standard, and also in Santana, which involved an exigent circumstance, after all, hot pursuit, and the court applied a probable cause standard not just for the underlying crime, but to think that an exigency existed. The last thing I would say is that the United States says that reasonableness is an easier standard to understand than probable cause. But as Justice Jackson observed, probable cause is as settled a formulation as you're going to find in the Fourth Amendment. It's a standard that officers have applied, that the courts have developed over decades and decades. As the court said in Dunaway, the familiar threshold standard of probable cause for Fourth Amendment seizures provides the relative simplicity and clarity necessary to the implementation of a workable rule. A balancing test, particularly a sliding scale test, will not only be unfamiliar to first responders, but particularly unfamiliar to officers and other first responders.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until Monday, the
argument.
Supreme Court hears oral argument in case about FBI conducting raid on incorrect house. We're going to circle back to this one because that sounds delightful. Oh man, it's just any note on a coffee table could be. Yeah, I mean, if you look at the notes that I have on my desk right here, like I'm just going to look like a serial killer. Is that an IJ case? I don't know.
First this morning in case 24-362, Martin versus United States. Mr. Jackson.
Yeah, we're definitely going to be circling back to this. That sounds fun. Yeah, I kind of get the sense it's going to be on remand. They'll probably write a clarification of the law and tell the state Supreme Court to reconsider. The Atlanta Orong no-knock raid. It's possible. I mean, the thing is, if it's in Atlanta, I mean, they could have just had like the wrong. It could have been like 131 Peachtree Avenue, and they accidentally went to 133 Peachtree Avenue, because in Georgia, those numbers are actually the same. It's really confusing. Sometimes it's actually 106 Peachtree Avenue. Because, see, you can live at like 133, but if you live at 133, you can't live at either 131 or 106. It's really tricky. Oh, man. Okay, let's take a look at this case that Matthew shared with me. This one was... Let me still haven't taken my advice about Nick Torres. Anthony or Antonio, seriously. What's funny is, like, I feel like I know so much about these different people at this point. Like, I know, like, Anthony Sledge. Like, I know his birthday. I know his social security number. I know where he lived when he was younger. I know where he lives now. Like, what if I ever meet this guy? It's gonna feel weird. So this is a decision. We're not going to so much look at the law here. Love tools at the right house. We're not worried about the decision here so much as we are looking at the some of the fun parts. This is just a really this opinion really speaks to me. This is Judge Easterbrook, 7th Circuit. It's kind of a, I think he's a Posner clerk at one point. Assignment design, entered into a lease, blah, blah, blah. We don't need to worry about this stuff. It's about, real estate law. Talking about like procedural rules and whatnot. Here we go. This is where we get to the good part. Get to the end here. Oh, thanks, Mary. Yeah, I really like that. I haven't really watched a full oral argument before. I think I watched maybe one in Georgia, 1 and 2 in Georgia, but I haven't done any Supreme Court ones. That was fun though. I like that. Okay, so here we go. Assignment design's sole argument has been that anyone may represent an Illinois corporation in federal court. That argument is misguided, so the appeal must be dismissed. So now we're getting the good part. We are publishing this opinion not just to make these obvious points, but also to urge all lawyers to read and follow this circuit's Practitioner's Handbook for Appeals, which is available on the court's website at Court of Appeals 7th. You can see here. The handbook discusses the uses of reply briefs and docketing statements, subjects on which Assima's Design's lawyer may need a refresher. And more important, for the sore eyes of judges who must read copious legal materials, the handbook at 170 to 77 contains some important advice about typography. Oh, James, really? Hold on, I'm going to make you a mod so you can share stuff, because you share stuff a lot. There we go. Let me see here. Of the many typographic suggestions in the handbook, the one most important to readers is that lawyers choose typefaces, often called fonts, suited for use in books and other long-form presentations. Page 174 offers this advice. Both the Supreme Court and the Solicitor General use Century. Professional typographers set books in New Baskerville, Book Antiqua, Callisto, Century, Century Schoolbook, Bookman, Old Style, and many other proportionally spaced serif faces. For those of you who don't know, oh my god, am I going to explain all this? Proportionally spaced, there's monospacing and proportionally spaces. In monospace, each letter takes up like the same amount of space per letter, even if it's like I and what's a wide letter? W? So each I and W would take up the same width, even though one word is wider than the other. That would be monospaced. But proportionally spaced, like L is going to be narrower than, like, I don't know, What's a wider word? Why, I guess. They mentioned Palatino in here. Don't worry about that. So that's what proportionally spaced is. And serifs are these little lines on the end of letters, like this here, kind of, or like this. This is a serif. What? Why are you not do what I tell? Okay. Or like this here, that's a serif. These little like liney things on the end there. So they want proportionally spaced and serifs. Let me see. Any typeface with the word book in its name is likely to be good for legal work. Baskerville, Bembo, Caslon, I have no idea how to say that. Galliard, Jensen, Minion. I've used Palatino recently. Pontifex, Stone Serif, Trump Medieval, and Utopia are among the other faces designed for use in books and thus suitable for brief length presentations. Use the most legible face available to you. Experiment with several, then choose the one you find easiest to read. Type with a larger X height, that is, in which the letter X is taller in relation to a capital letter, tends to be more legible. Oh no, this gets good. Don't worry, guys. As Matthew says, we're not at the sass yet. This is going to get real disrespectful. This is just like, oh, Bedoni. I've mentioned Bedoni here. This is going to get sassy. Oh my goodness. For this reason, face in Bookman and Century are preferable to faces in the Garamond and Times family. Times New Roman is falling out of favor. You should also shun type designed for display. Bedoni and other faces with exaggerated stroke widths are effective in headlines, but hard to read in long passages. Jason Epstein, who represents Assignment Design, did not heed this advice. His brief is set in Bernhard Modern, a display face suited to movie posters and used in the title sequence of the Twilight Zone TV show. I don't think it does, James. Fortunately, we wouldn't want to have the court worry about that. Wikipedia explains, a somewhat decorative text typeface, it is distinct for its low X height, elongated ascenders, and relatively short descenders, giving it an appearance of height without requiring excessive leading. Serifs are wide and splayed, citing to the Wikipedia page for Bernhard Modern. Those are not characteristics that conduce to easy reading of long passages. Most of this opinion, you might notice there's a subtle difference in the typeface or font here. You see here, it looks a little different. Most of this opinion is the 7th Circuit's normal types, 12-point Palatino linotype. We set this paragraph and the next in 16-point Bernhard Modern to give a sense of what Assignment Design's brief looks like, and of how much harder it is to read a display face than a typeface designed for books or legal briefs. Passage of 12-point Bernhard Modern, such as the sentence, requires a magnifying glass because the X height is so low. I actually kind of like this font, to be honest with you. I don't hate it so much for reading. I would never put a brief into this, but I don't hate the way it looks for reading. Matthew Butterick, a type designer turned appellate lawyer, offers advice similar to that in our handbook. See Matthew Butterick, Typography for Lawyers, or his website of the same name. He provides a different, though overlapping, list of typefaces good for use in legal briefs. If you don't believe our handbook, believe Butterick. His book and website include many examples of what to emulate and what to avoid. Judges are long-term consumers of lengthy legal texts. To present an argument to such people, counsel must make the words easy to read and remember. The fonts recommended in our handbook and Typography for Lawyers promote the goals of reading, understanding, and remembering. Display faces such as Bedoni or Bernhard Modern wear out judicial eyes after just a few pages and make understanding harder. We hope that Bernhard Modern has made his last appearance in an appellate brief. This appeal is dismissed. Yeah, he got pretty sassy with it.
Giacomo?
I'm probably going to get copyright struck for this, but I don't really care. Sounds like a chef. Ah! What is this? Okay. Oh, yeah. You know, what are these? I use this font charter for my own stuff, but I don't use it when I change it to something else when I submit. This was designed in like the 80s or 90s for like specifically for readability on a monitor. But and this is Palatino, which I kind of like too. These are all free fonts, by the way. You can just download these for free. But I'm a fan of all of them. What should I do now? Should I just talk some trash about Oh yeah, thanks, James. I saw that. I just opened them up on my other thing here. I also want to look at the Curtis Flowers case soon. That's the case where he's been tried like 5 times. Ooh, I want to give another a little preview of something else that I want to do a video on soon, but I haven't like read through it enough yet to like be prepared. So I guess I'm just gonna open it and show it to you, and because I'm not prepared. Doug Weinstein's referenced this a few times, but I haven't really seen any coverage of it. Oh, look, this is just over 2 years ago. This involves the so there were 2 jurors that the state wanted to strike really badly. And at one point they actually hired somebody to follow the prospective juror around. There were 2 of them. There was juror A, and then there was also a juror B. So they spent like a crazy amount of money. Yeah, that would be a better way to put it, Matthew. That's not creepy at all? No, not at all. Definitely no problem with that whatsoever. But they filed this 18-page brief with this very not insane emphasis. Yes, YP. That would be correct. But look at all this. You can't emphasize everything. Like, look at this. This is like if you see a note that looks like this on my on a notepad on my coffee table when you're looking through the windows, you can come into my house because I've probably had a mental breakdown. Does Buttrick support bold underlining? I don't think that's the only time I'll do bold underlining is if I've already used bold and underlining. Or because, I don't know, I think I can get away with it. But generally, I think you should choose one of bold, italics, or underline. I try not to double up. Sometimes I do in headers because just to have different styles. But I think bold would be fine here. And checking the windows exactly. Oh yeah, Jay. Oh man, I'm looking forward to hearing about your jury selection. But yeah, so they wrote this entire brief. I think it was the other one that was more psychotic. This is the one where I think they followed him to find out where he lived. Because the theory was that he lived in a different county, if I'm not mistaken. I think they thought he had an apartment in DeKalb County or something. So they were like following him around to find out like whether he lived primarily in one place or another. My goodness. Where are you? Here he is. This is the one right here. Juror B's residence in Cobb rather than Fulton County renders him incompetent to serve under such and such. Although Juror B listed his home address on the juror questionnaire as being in Fulton County, during the voir dire, Juror B testified to the fact that he holds a residential lease in Cobb County. But testified to the fact that other than himself, no one else resides at this address. When asked by the court why he has a residential lease in Cobb, he said he needed somewhere to stay. I think they just repeated themselves. This is just the same thing. When asked by the state why he has a residential lease in Cobb, that's where I wanted to live at. I don't know why they didn't want to underline and bold this part, but whatever. I wanted to have a place. When Jerby asked about the Fulton County address that he claimed is where he lived, Jerby testified to the fact that his name is not on the deed to the residence. It sounds like he lives with his parents, and he has a place in Cobb, too. Oh, James, that actually, that's how prosecutors lose case because he failed to get into evidence the crime occurred in the jurisdiction. That came up in the Darren Mills case that I've covered a couple times. There were like two locations. It's basically one continued crime, allegedly, and part of it, was in one place, part was in another. And one of the two, the latter of the two, was really close to the Fulton County line. They decided that there was enough in the evidence, but yeah, I remember that, James. Didn't Eric Adams have the thing where he had like the apartment in New York that he had clearly never been into, and he was trying to do he tried to give a tour of this apartment that he'd clearly never been in. That was like, there are some things in politics that should transcend party lines. And the tour was one of the most ridiculous things I've ever seen. I mean, it's like the George Santos, like, it doesn't matter how you feel about politics. Like George Santos, he's just a silly guy. It's like the Eric Adams apartment tour, the George Santos situation. Like, come on. Oh, man. Oh, man. He moved into his son's apartment. Yeah. That's definitely something a grown man would want to do. But look, then they just switched to italics here. But yeah, I believe they followed this guy for an extended period of time with a private investigator because they wanted to show where he lived. Video showing how hard he works for the clock showing is 10:30 a.m. Oh, this isn't even the worst one I've ever seen. Is that legal? I really don't know. I guess it probably is, but it's definitely weird. Oh, here we go. I didn't even notice this the first time. On the 15th, this is the issue. Doug mentioned this. This is the issue. On the 15th and 25th days of surveillance, Juror B's car was not at his Cobb County residence, but neither was it detected by license plate readers anywhere near his mother's residence. This was the issue. They were using license plate readers, or LPRs, in connection with their voir dire research, which I believe is not permissible. You're not supposed to use LPRs in connection with voir dire because, the whole surveillance thing. It's kind of bad to do that. I didn't notice that the first time I read this. But yeah, this whole section here. Testified he leased it past 8 or 9 months. He lived in Fulton for this period. Surveillance conducted by the state confirms that Juror B has spent the night at his Cobb County residence for 28 out of the past 30 nights. Additionally, LPRs, this drives me crazy. Like, I'm not going to explain why. Have placed Juror B in Cobb County more than 300 times between August 11th and August 3rd. The LPRs further show that when Juror B does enter Fulton County, he goes nowhere near his mother's residence. LPRs nearby as mother residents are provided from September 3rd and October 3rd, 230 hits. So they were just conducting this month-long, probably months-long surveillance of this juror just to get him off the jury, which is funny because they got fucking just destroyed in this trial. But yeah, it was kind of wildly over the top. Why isn't Doug on here? Doug's not even on this list. Oh, there he is. I don't know if they're using Flock, but I believe they have Flock. Flock now. Hey, Ashley. Yeah, I guess I kind of just like did, you know, my thing on this matter. Maybe I'll do a full thing at some point. There are like so many interesting little there's so many little motions in the YSL case that never really, I shouldn't say never got the attention, but that you know, like the YSL case kind of blew up after the motions happened. There are a lot that are really interesting. Like where they go through all of these song lyrics of all these different people. And they just list, like they have a Juice WRLD song. They have B Slime, who literally neither of these people are defendants in this case. Literally neither of these people. This Y&W Melly, you see here where it says Y&W? That is not YSL. And then they say Young Thug and Gunna, but like, then the people they give are not Young Thug and Gunna. They quote, you can see here, Melly and B Slime. B Slime, there are actually two B Slimes. I learned this, and I want to share it with everybody as often as I can, because it took me forever to understand this. There's B Slime, I don't want to give his full name, but this is YSL. Then there's another B Slime, whose name is, I can't remember, but is Y&W Melly's brother. They're different people. But this B Slime is Y&W Melly's brother, not the YSL B Slime. So literally neither of these people, both of these guys are from Florida. They're not even from Atlanta. Neither of them are in YSL. Untitled social media. Oh, man. This fucking... Sorry, excuse me, I was about to say something. This gentleman... Hold on, how can I get a clown emoji? There we go. This guy right here. That's better. Let me just get rid of this real quick. No. Why is that not working? Man, my joke format's not really working now. That's disappointing. Oh, well. This guy has, he's worked as a criminal street gang investigator for like 6 months in his entire life. He's such a clown. I can't stand that guy. Oh, this is much better. There we go. Oh, by the way, he was fired from this job. Thank you, Aaron. I should go through this PowerPoint at some point, the Operation Planners PowerPoint. Look at how young Woody is here. Bloody Jay. He was indicted in a different RICO case. I would love to see that up again. Yeah, the very intensive gang training material. You need to sit still for 8 hours and to get 70% on a test to be an expert. What other fun ones do we have? Multiple choice for gangs. I mean, I guess it's probably like A, B, or C, and if it's Bloods, it's B, and if it's C, it's Crips, and as long as you follow that guidance, you'll be fine. Didn't Miles get indicted for Make America Slime Again clothing? I don't know what he got indicted for. I really can't wait for the Farley case to move forward, just so I can see how fast that new case falls apart. When I make jokes about Carlson on Carlson, this is what I'm referencing right here. Substance have a license plate? No, because they have the right to travel. You don't need a license plate. There's one time I was like, after drinking, I just started going through documents in Control Effing Carlson to see how many results there were. How often they cite to Carlson. This isn't even a lot. Yeah, if you have the right flag, it means that you're an Admiralty law. If it has the gold fringe around the flag, I should do a sovereign citizen stream. That would be fun. Do some wild stuff when I shut up, Aaron. I feel attacked. Oh man. This is just one motion. This is one motion. Look at this. Like, what are we doing here? Look at this. What is this? It keeps going. There's more. They use the word Carlson one, two, three, 8 times in one footnote. You can't use Carlson 8 times in one footnote. That's irresponsible. That's insane. Look at that. Ooh, I need to change the color back. Oh, I don't have a green on here. I change that back. There we go. Look at all these Carlsons. Look at this. This has 9 Carlsons in one footnote. I should read some sassy actually, let me show you guys my little thing, my little file. So these are all the YSL motions that I have downloaded. I don't think this is all of them. But at some point, I want to go through more of these. It's like George Foreman, Georgina, Georgette. And of course, the greatest moments of all time right here. What is the status of the other YSL cases? Which one? Like the... Ooh, this is the wrong folder. Oh, I think they're all done now. They're all, they should all be, all the RICOs should be done now. They're all resolved. Mostly like roughly time served, or that's what I should do actually, is I should do a stream where I go through all of the different dispositions and show how many of them were like effectively no time added, either dismissed or like no time added sentences. I don't know what happened about that one girl I tweeted about that had civil asset forfeiture of 97. Yeah, I don't know about that. If you like share it with me or like get me the name, I'll definitely look into it. Waiting for the next Wolfenbarger stream. Oh, I have some stuff for that. Let me show you something actually. What was her name? Cheryl something? It's going to be more of a Cheryl McCollum stream than a Wolfenbarger stream, because I have some questions about the propriety of what she's doing, given that she's active law enforcement and like going onto TV and podcasts and like explaining that somebody's guilty despite the fact that she's in law enforcement, and literally everything she has is Brady. It doesn't seem like they're turning him over. Oh yeah, no PYP. Actually, I think I am going to wrap up the... I don't really have a super developed plan. But I really like doing the watching the Supreme Court case with you guys. That was fun. I'll probably do that again. Maybe do the FBI wrong house raid of 133 Peachtree Street. The Celebrate? No, I didn't. So many people have told me to watch the Celebrate interview. I know Matthew mentioned it yesterday. Is it really that bad? I can watch that tomorrow. I don't mind that. No, James, I have that on my list, though. It broke Steve Gosney. You know, I'll listen to them right now, actually. It's just them blowing smoke, but a lot of covered it. Yeah, there's a guy, that reminds me, there is, I can actually probably pull it up, let me see. This was my bestie Rachel Kaufman's case that she actually won it now. It's should be a new hearing on it soon. This case. Where are you? Oh, it's only 10 minutes? Okay, we can do this. Oh, wait, no, this isn't the interview. Is this the interview itself? No. No, that's the wrong one. How long is this interview? I see the Young Jerks had an hour and 48-minute episode on this. It's short, but it's 2 parts for whatever reason. Oh, I see part 2 here. I see. Ask the expert. That's kind of, calling yourself an expert is kind of cringy, I gotta be honest. All right, I'll watch the first one. Forensic science is another, okay. I can do another 10 minutes. Let's see. I think I'm probably gonna have to break it into 2 parts. I'll watch the first one though. Let's see. Ask the expert. Call yourself an expert. Like, I don't even call myself an expert. It's just, if you have to say it, you know?
This case is like a super onion.
Infamous Google search.
Okay, first off, okay, I know they haven't really said words yet, but what is this? What am I looking at? What is this background? This is just clearly just a Zoom interface. Like, what is this? What? This is your tech expert? This is what you have for me. You're a tech expert, and this is what you're going to show me. This is your king? Okay, this is bad. This is already terrible. Okay, we're 3 seconds in, and I've talked for a long period of time, so let's continue.
To dying of cold.
Celebrate updated fiscal analyzer.
This Google search became a pivotal piece of evidence for the defense.
Hello, everyone, and welcome to us.
How is it innovation for a safer world? It's only after
Special edition of Ask the Expert. I'm Heather Barnhart, and I'm here with Ian Whiffen, the infamous genius who was tied to the Karen Read trial. We are here for the very first time to discuss this with you.
We are coming on the air with breaking news.
Karen Reed walking out of court with hand over heart and a major win in her murder trial redo.
Just to catch you up.
What was that? Okay.
In case you've lived under a rock or avoided social media and the news, Karen Reed is a Massachusetts woman who earlier this summer was acquitted of murder in her boyfriend's tragic death.
She was also acquitted of manslaughter, just to be clear.
This was her second trial.
Yeah, actually
so Ian, I believe the first trial ended with a hung jury, and it was a mistrial, so she had to go through it twice. You had to go through it twice.
Yeah, you were paid to appear twice. I wouldn't say you had to go through it twice, but sure.
More of her background. Her boyfriend, John O'Keefe, was a Boston police officer, and in January of 2022, he was found dead in the front lawn of another Boston police officer's home in a Massachusetts suburb in the early morning hours in the middle of a blizzard.
Massachusetts, Boston suburb.
I'm not going to get into the details of all of the basics and the foundation of this case. You have read it, you've heard it. I'm sure Ian will allude more to the digital evidence and what that spoke for. But the prosecution accused Karen of driving drunk and backing into John with her SUV and then fleeing the scene, leaving him to die in the snow. The defense said that Karen Reed was innocent and dropped John O'Keefe off.
The defense said that their client was innocent? The audacity.
Off at home and left.
That's not what they
said. He was beat up in the home and dumped on the lawn. So this is where the conspiracies really came out. The police officers,
I mean, that's just literally a conspiracy allegation.
Apparently were involved and covered it up. So everyone has their own opinions. We've seen them all over social media, but that's really the basics of the case. This case is like a super onion with so many layers. The more you peel back, you're like, what is actually happening?
That's how onions work for you? When you peel, okay. So so when you peel back an onion, that's what you think? What is happening? I mean, that's just kind of how an onion works. Once you get through a layer, there's another layer. That's just the nature of an onion. You shouldn't be surprised when you peel an onion and you find more layers. Like, you should understand how an onion works, especially if you're going to be peeling one. But let's just revisit. I want to hear that again. That was funny.
Social media, but that's really the basics of the case. This case is like a super onion with so many layers. The more you peel back, you're like, what is actually happening?
Yo, dog.
It was a media circus, extremely high profile, and our very own Ian Whiffen was kind of the ringmaster at times of that circus.
I would hope the judge would be the ringmaster. I mean, I probably wouldn't tell them that it was a circus, but a huge witness. So if he sees himself as a ringmaster, he fundamentally doesn't understand what his job is.
So Ian, seriously, I applaud you. One, for your patience and not flipping out. I know many times I wanted to flip out on your behalf, so I was emotional.
It's your job, dipshit. What are you talking about? It's literally what you're paid to do. This is your profession.
Emotionally in this with you, but you did a fantastic job. For those of you that
you lost, but you know.
Don't know Ian, he's not just the brilliant mind of forensics. He is also our decoding manager here at Celebrate. So Ian takes all the things that are stored in that lovely brain of his and tries to dump it back into the tools for everyone else that needs Ian's brain to help us solve our digital forensic investigations.
That made no sense.
All right, Ian, you ready for some questions?
I am. Go for it.
And then we'll have some fun at the end too. All right, why were you...
He's clearly miserable, which I kind of respect. She did say lovely brain. He clearly doesn't want to be there. I completely respect that part. Totally get it. I'm with you, Ian. I feel you. That's fine.
Brought into this case.
Okay.
It's because they needed an expert for the cell phone. What do you mean? Why did they?
So I initially got involved in this case after a true crime podcaster contacted Cellbrite asking for clarification.
This is a bad start. Why would you even admit this? You're trying to be... Okay. For 3 minutes in. We're almost a third of the way
because
through.
Of some things that he'd seen in other people's blogs, some things that had been tweeted related to an artifact that Physical Analyzer had passed. Basically, police had obviously extracted a bunch of phones at the time of John's death, done their own analysis, including the analysis of a witness's device, which was written off at the time as not containing anything relevant to the case. About a year later, defense experts took that same extraction and ran it through Physical Analyzer as well, and now found a timestamp which they thought was a smoking gun. The timestamp itself was related to a Google search, the infamous Google search, "Hoss Long to Die in the Cold."
By the way, none of this answers the question. This is all. The question was, how did you come to be involved in this case? But
which is an obvious misspelling of the term "How Long to Die in the Cold." I'll say this search.
I've actually thought about this. Everyone says Hoss. It could be hose long to die in the cold. And long could mean like desire. And so it could actually be just a very dark statement. You gotta wonder what these things mean.
It's actually been found initially by police using Physical Analyzer 752. But at that time, the timestamp attached to it was around 6:23, 6:24 a.m. after John's body had been.
This actually says how long T die in kicked.
Found and therefore deemed not evidentially significant. However, when the expert for the defense took the same data, they used a newer version of Physical Analyzer. This newer version had additional support. Obviously, we always add support for new artifacts as time goes on. And this new artifact support for a database called Browser State gave a timestamp of 2:27 a.m. For that same Google search. And that's important. 2:27 is a really important time because that would mean that this is around 3.5, 4 hours before John's body was found, implying that somebody had some knowledge.
Again, the question was, how did you get involved in this case?
That he was outside dying in the cold before anybody should have known that that was the case. So this Google search became a pivotal piece of evidence for the defense to try to prove that someone other than Karen was responsible for John's death.
They don't need to prove it.
A few things. I have many comments.
Okay, so let me break it down. So they added support. So this guy added support that created in his taking his theory, his version of the software, his company's version of the software is what gave the result saying 2:27 in the morning. So like you did this, to be clear.
Comments on this one. Celebrate updated Physical Analyzer based upon your research and what you learned in that case, so that people who don't understand how to validate don't have time to validate, and for better lack of other terms, press buttons to get answers. The answer will be correct in their face going forward.
Yeah, generally when you update stuff, you want it to give correct results. That's kind of like an idea of how updates work. You're not going to like make it stupid, right? Oh, well, maybe he will say that is what he did.
Yes, I think we always try to provide information which is correct to the best of our knowledge and ability at the time based on the research. We always want to give information which can be verified by the examiners. And in this case, once I started to look at the data and look at the evidence, I determined that the timestamp in the Browser State database was related to the time that the tab, so the browser tab actually took focus, and not the time that the search occurred or the navigation event occurred. So essentially, if you imagine opening up a brand new tab at 10 a.m. in the morning, using it to search for 30 minutes or so, visiting numerous web pages during that time, when you eventually close that tab, a record's created in the Browser State database saying the tab opened at 10 a.m. The last page that was visited, the one that was visited at like 10:30, is this. So there's no correlation between the two. And that's essentially what my research was focusing on, that timestamp is not necessarily the time the page was visited. It could be before, it could be after, but it's irrelevant to the actual.
So were you wrong when you updated the software, or are you wrong in your later determination? Which time were you wrong? Which time did you make an egregious error? Why should you believe you now instead of the software that you made?
URL. So based on that, we updated our decoding.
Which time did you fundamentally fail at your profession? Both,
to
actually.
remove any kind of confusion and to ensure that, you know, we give you the web page that was visited, but we can't say that this is the time. So we just remove the time altogether because we don't.
And I think that's way better. And
So you completely failed, and now you changed it again, and now you want us to believe this is your third version.
something I wanted to comment to some of the social media
don't care what you
trolls
wanna
who
comment.
have zero digital forensics knowledge.
Yeah, you just admitted like fundamentally screwing up, so maybe you should take a backseat.
In their bodies, but think they know better than our very own Ian Whiffen.
I don't think I know better, but I can tell when somebody, contradicts himself. He can't be right both times.
Tools cannot be static in nature. A static tool should never be used in a forensic lab ever because technology is constantly changing. These apps change, browsers change, and we adapt to it. So we have to.
Yeah, but this is years after the fact. So we're not talking about changing. We are literally talking about a static set of data. That is completely irrelevant.
Just keep the research going and keep feeding our tools. And
Like there's a static phone extraction. We're not talking about like changes over time. Like, of course you need to update the software over time, but we're not talking about, we're not literally talking about updating software and changing extractions. We're talking about a single static extraction.
them better.
Of course, yeah. I mean, we have to update our
Completely misses
tools
the point.
constantly to account for bugs that may exist in our software, bugs that may exist in the applications that we're decoding, changes made by vendors, or simply because our understanding changes.
I mean, sure,
this is a
but that has
perfect
nothing to do with
example
this.
of where the testing that was originally done focused on a particular use case, but this case brought to light additional use cases and different ways that data can be populated.
The use case of checking when something was Googled, yeah, that's an exotic use case. I could never foresee the importance of that.
And the possibility.
Like, why would you put time? Like, you put time next to the search, so obviously you know that it's a relevant use case.
That timestamp probably isn't accurate.
Then why did you put it in there at all?
Great. So what you're really saying, Ian, is that Celebrate chose to make the tool better for users, and we weren't trying to be some part of the giant conspiracy of Karen Reed.
Oh, absolutely.
That's
I
just-
mean, we would never modify our decoding or our tool for any other reason than to do what we think is forensically best.
Yeah, but you didn't.
We
because
want
you
to
messed
give
it
the
up.
users the information that we believe is accurate.
Yeah, but you didn't.
And in this case, this particular artifact is super easy to validate.
And yet you didn't do
can
it correctly.
any test device and test this out yourself. If we were to modify our software for any kind of nefarious purpose, it wouldn't take long before users realized and quite rightly took us to task for doing things wrong. Right? We only do things because we think it's right.
Well, Ian, I thank you for your time
Why
and what you
is
do
the
for this
music-
community and for our
Why are they playing her out like it's the Golden Globes or whatever award show, the Academy Awards? Like, you don't need to. It's your own show.
viewers. Next up, part 2. We're going to discuss testifying in court. Best practices, how to be cool and calm and collected like Ian himself.
Like, you lost, right? Like, why are you using this as an example of best practice? Like, you lost. What do you mean best practices? You lost. This is a terrible example. Why don't you use examples from a case you won?
Especially in a case like this that is so conspiracy driven, where there are people that firmly believe one way or the other. They were willing to like put themselves out there on the line for is she guilty, is she not guilty?
What is she talking about?
We're also going to have some fun. We're going to read some of the mean tweets that were thrown Ian's way by the social media trolls of the world. So, Ian, again, thank you for your time.
Thank you.
Okay, I
This
said I wasn't
was
going to do this.
another level.
Let the evidence speak to you.
Karen saying that I was
The evidence speak to you. The evidence told me.
right is
I just saw this tweet.
I knew I was right with it.
So what do you think?
Yeah, but you contradicted yourself. You literally can't be right.
Hello, everyone. Thank you for
Literally
joining
can't
us
be
for
correct.
part 2 of this
It's just
special
which
edition
time
of
were you
Ask
wrong?
the Expert. I'm Heather Barnhart, and I have with me again Ian Whiffen, and we're discussing the Karen Read case. If you didn't watch part 1, go back and spend the time to understand how Ian got involved in this case,
I still
some
don't
of
know
the
the
chaos behind it.
Now that I think about it, he never actually answered that question. He never actually answered how he got involved. He was just talking about like a podcaster asked him a question, which didn't really answer the question of how he got involved. Like, how did he get hired? He never really, he talked for like 10 minutes, but didn't actually answer
And what
the
the
question.
key digital evidence actually was.
Which is what you want in an expert witness, the inability to answer a question correctly.
So Ian let the evidence tell the truth, and he simply testified to that truth. In part 2, we want to focus on that. So Ian was amazing in court. The judge was even smiling at you, Ian, when you were done
You lost, to be clear.
testifying. I felt like everyone wanted to give you a round of applause. But
You lost.
in addition to this case taking its own life form, the Karen Read supporters, all the noise at the courthouse, so much media chatter everywhere, you turned off your notifications.
You are literally making a YouTube video about it. What are you talking about? This, like, you are affirmatively seeking attention to his work in this case. You can't be like, hey, look in this YouTube video, we're complaining about the attention that he got in this case. Like, you are yourself seeking attention. You can't. Okay, you get my point.
You were getting distracted by all of the noise.
Wait. Are you saying that he was getting distracted by the social media?
At the courthouse, so much media chatter everywhere, you turned off your notifications. You were getting distracted by all of the noise. Before we even talk about how you prepared to do that, I will say, even in the Idaho.
Why did he need to turn off his social media notifications? He shouldn't even be looking at social media at all. But he was getting distracted by. Does he mean? Did she mean the literal noise? Because he really shouldn't have been reading any of that stuff.
Murder prep. When I asked you, Ian, should I watch these things? Should I listen to these things? And you're like, absolutely not. Isolate yourself. That was some of the best advice that I think all of us could take. You need to let the evidence speak to you and not really let social media or the conspiracy theorist out there sway you in one way or another.
He really shouldn't know anything about the conspiracy theories.
All right, so we're going to talk about prepping, Ian. Prepping for this case, which we know you spent many, many hours doing. If you have not
Yeah, that's like literally your job. That's the whole idea.
watched Ian testify, it's on YouTube, it's on Court TV YouTube, it's everywhere. I've had many students that come up to me after I teach for SANS and they say, hey, we make all of our new people watch this. Hey, we make even our trained investigators watch this. Because the way Ian can explain extremely technical details to, I think even my dad would understand what you meant, is astounding.
What? Why were you throwing your dad under this? Your dad's not even here to defend himself. It's like my dad is dumber than all of these people. Come on. Justice for Heather Barnhart's dad.
So I personally thank you, and I love learning from you and watching you do this. But
Also, you lost again.
this is truly the masterclass. If you want to learn how to do courtroom testimony, you watch Ian Whiffen.
You lost.
I'm going to give you a little applause here.
You
This is
literally
also
lost.
why my family, the kids think Ian's a doctor because he's so smart. So he's Dr. Whiffen, according to our household.
There's zero chance that that's a thing. Kids don't know that. Kids think doctors are medical doctors. Like, what are we doing?
But I want to break you through, or walk you through, I should say, key concepts and advice and methodologies you use for people to testify successfully in court. So I'm going to give you your points and then
Again, you lost.
have you just chime in with what do these actually mean to you?
Twice, really.
Sure.
The first one, know your evidence and know it
do I really need somebody to tell me that know what you're talking about is good advice for an expert witness to be an expert?
Deeply.
So really it's easy to just create a report and present the data. But you really need to understand what that data means. How did that data get on the device?
So fucking stupid.
Why is it there? What are the other possibilities that could explain it? Is it deleted? If it's deleted, how was it deleted?
What is it?
All these kind of components
it?
that really mean that you understand the data rather than just showing what the data is on the device. Like, did somebody do a search, or is it the result of an autocomplete? Were they at a location, or did they just search for the location? There's so much data you can get from a device.
This is supposed to be an example of him clearly explaining things. So
that can mean different things. You really need to understand what you're testifying to.
I love that. And I've been feeling the pain of that one myself.
I bet you have.
All right, next up, identify the make or break evidence. So
really
make or break in quotes.
Yeah, so I think this comes with experience. After a while, you start to recognize not just which artifacts exist, but which are the important ones, which are the ones that you really need to spend additional time validating, verifying, testing, researching.
Oh, so you
if
just
it's
decide
simply
which
like an
ones
SMS message, for example, that exists on the device, it's pretty straightforward. We know why the SMS message was there. So it may be really good evidence, but it's also really easy to explain. And I think everybody in the world understands what an SMS message is. But if we're talking about something such as a location, for example, there are multiple reasons a location could be there. It could be really important information. So you really need to know why it's there. And that's why you kind of focus on it and do the...
It's important, so you need to know why it's correct? That doesn't, like...
But if we're talking about something such as a location, for example, there are multiple reasons a location could be there. It could be really important information. So you really need to know why it's there. And that's why you kind of focus on it and do the additional validation and testing.
What? Fantastic. All right, now the third one, which I think personally is difficult. And this is where I could let my mind run for days on end. How do you prepare for the toughest questions?
I let my mind run for days on end. Legitimately, I go over all of my reports. I'll just mention as well, my report...
Sorry, I read James on my chat, and I said James. I meant to say Ian.
Reports are pretty detailed anyway. For example, for this second trial...
So you prepare by preparing. That's fantastic.
I did about 150, 160 pages of reports. About half of that was the actual data, and about half of it was the testing, the research, the validation, everything that supported my opinion and my position that I made in my report. So having all that information there is available for the prosecution to read. It's available for the defense to read. Everybody knows where I stand and why I stand there, and it's also useful.
Okay, you just do your job is the answer.
For me while reviewing my evidence and looking back at it to understand.
Okay, this is just preparing. He's just describing what preparing is. Like, literally, he's just saying, I do my report and then I review it before I testify, which is, like, perfectly correct. Like, I don't have any issue with what he's saying. Like, it's accurate, but this could be a one-sentence answer. I prepare a thorough report and then I review it in advance of my testimony. Which is good advice, don't get me wrong.
And to remind myself, this is why I have that opinion. I've already tested this. I don't need to think about that
He's not wrong.
too deeply again because it's already on paper.
That's true.
I also try to guess what are the questions that I'm going to be asked. Like, what is the real sticking point of this data? What's the question going to be and how can I answer it? And there's no possible way that you can cover all bases. There was a few questions caught me out in this trial. But on the whole, I knew what to expect and I had a good idea what I'd be talking to.
Yeah, I think...
Yeah, I mean, it's kind of obvious, but, I don't have a problem with that answer.
If you put yourself mentally in both sides of the courtroom, it helps you be a better witness
Oh,
overall.
for sure. Put yourself in the position of the prosecution, of the defense, and of the jury. Like, do they understand, or are they likely to understand what I'm explaining here? How common is this kind of information to somebody who doesn't work in digital forensics?
Exactly. All right, so based upon that, your fourth tip is to tailor your approach on each case.
Well,
Yeah, this is really about how to conduct the digital investigation. Like, depending on the kind of case,
there is no way that this answer is going to be good for them. There's no way that this is going to be a good answer. They're just setting him up for failure here.
Yeah, this is really about how to conduct.
It depends on what result I want to reach, and then I tailor my approach that way.
The digital investigation. Like, depending on the kind of case, depends on how you approach the data. The example I typically give is if you've got a victim who's found at home, for example, location data may not be relevant because you know where they are, you know where they've probably been most of the time. But if you find a victim out in the middle of the road, in the field, or somewhere unexpected, then location data becomes a priority because you want to know where they were before this location. Similarly,
so you just decide what data is important before you commence your investigation. That's very sound.
Data may not be relevant if you're looking at a vehicle collision, for example. But if you're in more of a domestic situation, then communication could be key. So it's really about tailoring how you conduct the investigation and how you write the report based on the kind of investigation it is, to make sure that you're focusing on the right elements.
That was a problem with the question. His answer wasn't even that bad. Like, I know what he's trying to say, but the question was not set up to solicit a great answer. It should have been like relevancy of data rather than how do you approach an investigation.
Exactly. And I also think that we aren't sitting at a desk all day, every day, being investigators and examiners anymore. We are brought in to do specific things and validation and make sense of data that sometimes then expands to everything. So focusing on what's being asked, I think, helps, but then
Isn't that still sitting at a desk, though?
Speaking up when something doesn't make sense and needs to lead you down another path.
Yes.
All right, your final one.
That doesn't actually relate to your approach to the investigation. That would be applicable to all cases, I mean.
This is advice I could take in my everyday life. Block out the noise.
Okay, that's just your obligation as a witness. To not look at social media or observe the noise. Like, you are explicitly required to do this. This isn't really a suggestion.
Yeah, so this particular case was kind of unique to me. Like, I've testified in many cases before. Several of those have been relatively high profile, but this was another level. Personally, I found I had to turn off Twitter. I didn't open Twitter or X for probably about 8 months. I was very careful other social media platforms I was using to block out anything that was related to the case. I didn't want to know, basically. I don't want my kind of opinion to be shifted based on what I'm seeing online.
So that's a good answer, but the question framing was kind of less than ideal. It shouldn't have been block out the noise. It should have been follow the court's orders to stay off social media.
All I want to know is the data that's put in front of me. That is the data that I have to testify to and understand. I don't need that outside influence. So essentially ignore everything apart from the data.
It also didn't help when you had a team of people reminding you of something they saw. I just saw this tweet. It wasn't helpful to you. So we apologize, Ian.
Why is your team doing that?
We had your back all along. But that's what you were so firm in your mind on, yep, I'm just going.
Oh, okay. Excuse me. You're telling me that your team was reading tweets to you about the case in advance of your testimony? Not like random people, Like your employees are reading tweets about the case to you. You know, I'm less troubled by the fact that they do that than I am at the fact that they would put this in a YouTube video. It's like they don't even know that that's a bad thing. Like, I'm sure it happens. Like, let's be real. I'm sure it happens, you know, just practically speaking. But, like, they're putting it in a YouTube video for the internet to see, which tells me that they have no idea why it's wrong, or that it's wrong, or bad, or damaging. Which is almost worse than, like, doing it, you know, in the first place. Didn't they beat up the Aperture witnesses when they weren't sequestered? Yeah, I think so. Don't admit it exactly. Like, the fact that you're admitting this is almost more concerning.
Going to ignore it. Me, I probably would have, like, poured myself a glass of wine and walked right into that chaos and then cried.
What are you doing? I'm sorry. I need to stop stopping this. This is insane. I don't even know criminal law that well, but you're not supposed to do this.
Into my wine glass. So good for you.
Respect.
Seriously.
Down the line.
It's a lesson for all of us.
This interview is not doing this guy any favors. Like, his answers have, by and large, they haven't been, like, for the most part, they haven't been that interesting. He's kind of just, you know, repeating just kind of generic answers, giving generic answers, I mean. But these questions are setting him up to just look terrible.
But now we're going to do, historically, this has been called mean tweets. And I remember seeing Peyton Manning reading something awful about himself where someone said he looked like a horse. It was terrible to watch these celebrities read all of this. Ian,
who is that, Jimmy Kimmel?
You're a celebrity in our household. So I am going to read these mean tweets or mean X's, whatever we call it, and see what you think about this. And the names are blurred out, okay? If you want, I could tell you, sometimes I can see how many views there were. And there's a cuss word, so I'm going to say beep, okay? Ian Whiffen didn't explain. He misinterpreted data to fit the prosecution's case.
Reading is really difficult. But let's just take another crack at that one.
Explain. Say beep, okay? Ian Whiffen didn't explain. He misinterpreted data to fit the prosecution's case.
That's one more time.
Explain. He misinterpreted data.
One more time. Let's see if we can read this one correctly this time. Maybe
Ian Whiffen didn't explain. He misinterpreted data to fit the prosecution's case.
Nope, still wrong.
He screwed up in the first trial and changed his testimony and the @Celebrate report for the second trial.
Interesting. I don't believe my position changed at all regarding the Google search in trial 1 and trial 2. And
but did you manipulate your report?
I presented the data from the device and demonstrated my position. Obviously, we changed the tool to reflect the new understanding, but it was unrelated to what the prosecution may have wanted.
Yeah, upgrading your tooling is different than being a tool and modifying a report. So thank you for not. Only 79 views, Ian, so the world didn't really even see that person.
What, you just pulled a tweet with 79 views? How much?
All right, you ready?
Yeah, I don't mind. Like, again, like, his answers in this interview haven't bothered me that much for the most part. But what Heather is saying is just like, she's just saying like one bad thing after another.
I can't wait. I want to know what you guys think of the data. Tell Ian Whiffen to get lost and go do his job at Cellbrite.
This isn't even that bad. I can write a tweet way meaner than this. This isn't even like criticizing him. I want to know what you guys think of, like,
data. Tell Ian.
Like, who is this person? Like, to whom is this tweet directed? It's not even at Ian.
Ian Whiffen to get lost and go do his job at Cellbrite.
Just to be clear, like spelling your name Celebrite, this is even worse.
But you did do your job.
I did.
And then you lost. You did your job, and then you lost.
Tool. Oh my gosh, okay.
Yes, you fixed the tool because you messed it up the first time. It's not like it was broken by somebody out in the ether and we don't even know who. Like, you broke it, and then you fixed your own broken tool, according to you. That's the most generous interpretation, is that you screwed up and then you unscrewed up. Not that, like, you fixed this disaster that it just randomly happened out in the middle of nowhere. You did it.
Here's another one. Seriously, I'd be curious to know how many taxpayer dollars we spent solely in attempt.
Okay, we're gonna do another reading.
Seriously, I'd be curious to know how many taxpayer dollars we spent solely in attempt. Seriously, I'd be curious to know how many taxpayer dollars we spent solely in attempt to vindicate Jen McCabe. How much was paid to Ian Whiffen and Celebrite to change their whole software to try to discredit the 227 Google search?
This isn't even mean about Ian. Like, it's about how much was paid. I mean, I guess you can kind of infer that it's insulting to Ian, but like, they want to know how much was paid to Celebrite.
Timestamp.
Okay, I'm quite happy to answer this one. My flight and my hotel was paid for twice. Other than that, I received, and Celebrite received, nothing.
I love it. Okay.
You're a professional. Why didn't you get paid? You should have gotten paid something. Now I'm just confused about that. Like, even if that's true, that's really weird.
It because you care about the data.
Doing it because it's the right thing to do, for
But
sure.
no, it's literally your job. Like, what? I don't mind experts getting paid.
Yeah, and not saying who was guilty or who was not. For the record, anyone watching, I used to always ask Ian, like, so what do you think? So what do you think? Like, I just wanted his opinion, and Ian's like, well, the data shows this.
Retainer, yeah, that makes sense. Makes sense that there'd be some kind of oh yeah, that's right, like the training contracts and whatnot. That makes sense. That's right. I remember seeing that. Somebody tweeted about the ongoing contracts with Celebrite.
Exactly. That's all I can speak to.
All right, now this one.
She's making him look so bad. Like, he's not even, like I said, he's not even saying that much that's like incriminating or bad. But these questions are just setting him up.
54 views, okay?
54 views. There are tweets, like, there was a lot of coverage on this case. You can get something that has more than 54.
54 people around the world saw this. Ian Whiffen was not credible. Come on.
This is just a matter of opinion. This isn't even like, you can't even disprove that. That's just a subjective evaluation of his testimony. This dynamic is actually really funny. I'm kind of like coming around on Ian's side on this one. Because how is he supposed to respond to this? Look at his face.
And was not credible. Come on. You're not credible, Ian. All right?
Okay, I mean, everyone has an opinion.
59 views.
Oh, man. Like, how is he even supposed to respond to that? Ian Whiffen didn't destroy anything except Celebrite's credibility. Again, like, what is he supposed to say to this? It's just an opinion.
Ian...
Like, that's what juries do. They evaluate the trustworthiness and reliability of, I mean, witnesses in general, but also experts.
Whiffen didn't destroy anything except at Celebrite's credibility.
Okay.
Ian's reactions are actually really funny here. What is he supposed to say to this?
I mean, yeah, I don't know how to respond to that. I present the...
I'm totally on Ian's side with this one. I'm totally team Ian here. Like, what is he supposed to say? No, you? Like, Why would you read these to him? There's not even like a specific accusation. It's just like a subjective opinion.
Data, I believe from Celebrite's point of view, we did the right thing. And I'll die on that hill.
Well, Celebrate had your back 100% through and through on all of this. So I feel like our credibility skyrocketed because of your brain. So thank you. Seriously, we are trusted. You are trusted. I think.
No, but you work for you see, there's I wish I had my little highlighting tool right here. But it says Celebrate right here. You're just a Celebrate person talking about another Celebrate person, telling the other Celebrate person that he's believed. Like, you need somebody who doesn't have the little Celebrate here. Like, what really bothers me is that this is such a bad idea. And, like, just the execution of this interview is just so bad. You've admitted to so many improprieties. And, like, Ian hasn't even, like, said that much that's bad, really. I mean, there are a few things I take issue with. And some of his, like, assumptions. But for the most part, it's been, like, inoffensive, pablum. It's relatively uninteresting. But she just, like, keeps, like, eliciting these... Oh, man, I want to rewatch this tomorrow.
I think our team of experts are...
The team of experts that tell you the tweets about you in the midst of your testimony when you're supposed to be sequestered.
more trusted now than ever before.
Well, that's not what the tweets that you just showed said. You just gave a bunch of examples of people not trusting you. You should probably have found some tweets to the other effect, too. Just go on Julie Carpenter's Twitter. It takes 3 seconds. She's going to have more than 50 views, too. Just find a Julie Carpenter tweet. You can blur it out so nobody knows who it's from. You're good to go. It's not that hard. Just get a Julie Carpenter tweet. Ian Whiffin's so great. I'm sure there's one out there. Or the other one that yelled at me. The one that, like, blocked me and then unblocked me to, like, yell at me and then blocked me again so I couldn't respond. There's plenty of crazy people. You can find a tweet pro Ian. Just get one nice tweet in there. I never thought I'd feel bad for Ian Whiffin, but my goodness.
Because of
I
your
don't
testimony.
still, but...
All right. Now there's a new one. Okay? This is the best.
This is so funny. They're just roasting him on... Why would you do this to this guy? I feel like he didn't know in advance that they were going to be roasting him to his face. I really enjoy this.
One. So there's a picture of Mark Zuckerberg in his gray t-shirt and you
Okay.
from your Artex website, or your double black in your...
What? I mean, I kind of see it, but I also don't at all.
gray t-shirt, and it says, "Am I on crack, or is Mark Zuckerberg and Ian Whiffin essentially the same damn person? Hashtag Karen Reed."
My bank account would disagree.
You do look alike in this picture a little bit.
It's a very old picture.
You have the same haircut too, Ian. But
do you though?
You don't.
I mean, not really.
Berg and
I
Ian
don't know why
Whiffin
I'm
essentially
thinking
the
about this.
same damn person. Hashtag Karen
This
Reed.
isn't even a roast.
My bank account would disagree.
You do look alike in this picture a little
Weirdest
bit.
email activity ever. I mean,
It's a
vaguely.
very old picture.
You have the same haircut too, Ian. But you don't make as much money, probably.
Guaranteed.
You look like a nerd and you're a broke bitch. Loser. Why would you do this? Just called him a liar 5 times and they called him a broke bitch that looks like a nerd. Like... I love it.
All right. So beyond all these mean tweets and all this ridiculousness and people just being social trolls.
You trolled him. You just...
In the end, all over the battle of that
You lost.
2:27 a.m. timestamp. In the second trial, Karen Reed actually said she was not having her defense expert return because Ian Whiffen was right.
Are we hear from Richard Green in this trial?
No.
Why not?
I believe the evidence is all out and in part from Ian Whiffen.
How does that make you feel, Ian, that Karen said your
I
name
think that's what she said.
on the screen and said Ian Whiffen was right?
Did she say that?
In part from Ian Whiffen.
How does that make you feel, Ian, that Karen said your name on the screen and said Ian Whiffen was right?
Did I mishear that? Did she say that?
Return because Ian Whiffen was right.
Are we going to hear from Richard Green in this trial?
No.
Why not?
I believe the evidence is all out and in part from Ian Whiffen.
How does that make you feel?
Yeah, because I think the basis was that the defense thought that his cross, the cross of Whiffen, was sufficiently effective to not necessitate calling their own expert. Yeah, that's what I thought they were saying. That's bizarre. They just keep owning themselves here. I don't get it.
Ian, that Karen said your name on the screen and said Ian Whiffen was right.
So I mean, it was validation. I was already confident in my answer. I knew I was right with it. I was disappointed that the defense didn't put their expert on the stand to put his opinion across and to have that kind of debate and to evidence their position. But Karen saying that I was right is a close second. I'll take it.
I love it. And I can't speak on behalf of Karen Reed.
Also, why would you care if Karen Reed thinks she's not even like an expert in this field?
But how you did your report and the level of detail on what was on the device.
Again, you lost.
Versus what was on your test device and how sure you were. That had to prove to her that she didn't need an expert of her own because you were an expert for everyone.
I hope so. I tried to provide a balanced opinion. Like, I wasn't necessarily there for prosecution. I was there for the data. And whoever it helped, I don't really care. I'm just presenting the data that's there.
I love that. Well, Ian, seriously, thank you for being Celebrate's top expert in my mind.
Yeah, the dynamic here is kind of weird. I'm not going to, read too much into it, but it's kind of a strange office dynamic.
Seriously, and I'll say that because I saw social media or some public thing recently that Jared and I own Celebrate. So Ian, you are our favorite expert as an owner of Celebrate because you can't believe everything you read. But all your work that you put into this, all of the efforts, the education that you gave us along the way on your testing, I don't even know that you even consider that, but how much you educated all of us along the way has been phenomenal. We're lucky to be on your team. We love the work that you do. Thank you all for tuning in, but Ian, most importantly, thank you. We appreciate you at Celebrate.
Thank you.
That was remarkable. That was remarkable. Like, I never thought I'd feel bad for Ian Whiffen, but I actually did at a few moments there. Just the awkwardly reading tweets calling him a liar with 50 views was... I don't even have anything to add. Did they really do this video? It seems like they did it on purpose. Let's see the debunk. Somebody linked that before. Let me see. Was it this one? Oh, this is the debunk, right? This one? It is this one.
The data don't lie, people do. Okay, now I know Ian Whiffen is really dicking with us. How do I know? Let me explain. I've actually lost count how many times I've explained this. I've done it the technical way, the non-technical way. I've used a device of the same era and the same version as Jen McCabe's phone, and I've proved it multiple times. So how can I be so sure that I'm right and Ian Whiffen's wrong? And the answer is simple. I write freaking SQL code for a living. I went to uni, I learned the SQL language, not with pretty lines and columns and buttons.
Wait. Academy Dinosaur, an epic drama of a feminist and a mad scientist who must battle a teacher in the Canadian Rockies. Ace Goldfinger, an astounding epistle of a database administrator and explorer who must find a car in ancient China. Adaptation Holes, an astounding reflection of a lumberjack and a car who must sink a lumberjack in a balloon factory. Affair of Prejudice, a fanciful documentary of a frisbee and a lumberjack who must chase a monkey in a shark tank. African Egg, a fast-paced documentary of a pastry chef and a dentist who must pursue a forensic psychologist. I want to watch these.
And things that makes life easier. I had to write this stuff on a black and white screen in DOS. And what's Ian Whiffen's background? Oh yeah, he used to be a cop. Give me a break. Trust me when I tell you SQL is far more complex than SQLite, as if you couldn't tell just by the freaking names.
Yeah, I saw where that was going.
So what it records is far easier to work out than a full-blown SQL database. If Ian Fraudster Whiffen really wants to put his money where his mouth is, he could prove to you that the tab ID is the same on the 2:27 a.m. search as it is on the 6:27 a.m. search.
Makes sense.
I might have got those times a bit mixed up, but you know what I mean. So here's how it works. Each tab has a persistent ID. It's called a UUID. SQLite creates it when the tab first comes into existence. The tab's UUID is stored in a completely different place to the timestamps. For example, when it was created,
hire Heather Barnhart.
when it was
Probably not
last
so much.
accessed, when it was used to search, when it was closed. Those are all events, and events are attached to timestamps. Even deleting it is an event. So if Ian Whiffen wants to back up his claim that the 2:27 a.m. search and the 6:24 a.m. search both happened in the same tab, all he's got to show you is the tab's UUID.
Okay,
If it's the
I follow
same
so far.
UUID, then it was the same tab. And if he can prove that it was the same tab, then his theory actually holds water. Although I don't really understand how he thinks you can get mixed up between names like created at, accessed last, and things like that. But apparently he believes you can mix those things up, and therefore he no longer shows them in that software. Make sense to you? Actually, it probably doesn't make sense to you if you don't know databases, but I do, and it doesn't make sense to me.
That's what you're saying.
Literally everything that Jen did on that phone is an event, except for opening the tab. That is what created the UUID, and then the timestamps are all attached to events.
Okay.
It's true, I don't have access to the phone extraction, so I can't do what Richard Green did, which is most likely to write a very simple SQL statement like select event UUID, tab UUID, event type, timestamp, from history DB, where tab UUID equals whatever the 2:27 a.m. tab UUID equals. And in the world of coding, equals means exactly that. It has to be exactly the same, or else equals doesn't equate to the same thing.
I follow so far.
For example, 2 plus 2 does not equal 6 at 2:27 a.m. And then 2 plus 2 equals 4 at 6:24 a.m. That shit doesn't happen. It's not real. There's a half a dozen other flags that you can search in the SQL database that will tell you other information about that event. The Google server, for example, will store a value or several values on your phone as to whether you followed the search through to a website, actually looked at the website for a period of time, etc.
Yeah, I didn't really understand the whole video Jesus thing. That seemed like a whole debacle.
etc. Did Ian Whiffen do any of that? No. Why didn't he do any of that? Because he knows it will prove his theory is incorrect. He's still banging on today about the timestamp being the same thing as the tab UUID, and we all know it's not. Only because I have spent an inhuman amount of time trying to explain to you that it's not. Trust me, it's not. Think of it like this. The tab is a tangible object, like your fridge, for example. If you open it, its little SQL database would stamp it with a UUID. The fridge was opened. When it was opened is an event created at. What you looked for in there is an event searched at. What you took out of the fridge to go and cook or whatever it was you were doing is an event. When, keyword, you close the fridge, it's an event. And it's all attached to the same UUID. So tab UUID had A, B, C, D, E, F, G events happen between its opening or created at time and its closing time. It really is as simple as that. And Richard Green proved that those are different tab UUIDs. He didn't get to testify to it, but he did write a report, and his report is 100% true, whereas Ian Whiffen's report only focuses on the events, not the tabs. Yet his entire thesis is based on the tabs. So here's what I think about the whole scenario.
That makes sense.
If other forensic tools like Oxygen, MSAB, Magnet Axiom, for example, continue to show the timestamps and the UUID transparently, then that suggests Cellebrite's change was driven by something other than technical necessity, or something other than forensic necessity, i.e. being embarrassed on a world stage, for example. Or maybe they're just too lazy to answer the phone when they get inquiries about these timestamps. At the end of the day, forensic software should prioritise data integrity and transparency. It shouldn't be hiding inconvenient details that they couldn't be bothered answering. If you have two tabs with two different UUIDs, plus a deleted record, that is not a timeline issue. That's a data integrity issue, and Ian Whiffen should have been smart enough to ask for the actual cell phone extraction and verify it himself before he continued to put his reputation and Cellebrite's reputation on the line. From a database integrity standpoint, hiding timestamps is a red flag. The data structure hasn't changed. Safari's SQLite still records them. Cellebrite just stopped displaying them in their user interface. This means the timestamps exist in the database. Cellebrite's hiding is a user interface choice, not a data limitation. And the fact that Ian Whiffen couldn't drag up any other data out of that database to support his theory suggests the timestamps contradicted his narrative. So, if other forensic tools are still reading that data and the same SQLite database still shows full timestamp data, that suggests Cellebrite's change was presentation, not technical necessity. And if you don't believe me, go and ask Claude. You're all familiar with ChatGPT and Grok, neither of which are focused on coding or databases. Claude is. Claude AI is the one you're looking for. Go and ask Claude all these questions. The other AIs will give you general information, but Claude is written specifically for coding and databases and all that fancy stuff that most people don't understand. You can tell Claude, explain it to me like I'm 5, and Claude will do exactly that. It'll even write you an SQLite database that does exactly what your phone does. Anyway, I just wanted to vent about Ian Whiffen's dumb 2-part series, where he's still crapping on about the 2:27am search being in the same tab, and he can't even prove that it was in the same tab. End rant.
Not even an ad. I mean, I hope it was. She deserves some money for that. Oh man, that was delightful. Is Ian's report available? It probably is somewhere, right? Maybe I can read that on a stream or something. Learn something or not learn something. Yeah, that's good. That was super helpful. It makes sense. The different tab IDs, especially since they were different iterations of the search. But okay, I think I'm gonna call it a night. I gotta make dinner. But thanks everybody for tuning in. Ooh, I think pretty much everybody here is a subscriber. Maybe like the video, that helps. Ask developers, me nothing. Watching Ian Whiffen be roasted to his face was definitely one of the funniest things I've ever seen. Like they planned this in advance. Why didn't they till next time? I don't know actually. I could probably do one tomorrow, but I need to prepare something. I'm not sure what to do. I could maybe do that FBI case, the Longhouse raid or something like that. But if not tomorrow, then probably Tuesday. It'll probably be at like 3 o'clock or 6 o'clock Eastern. Either tomorrow or Tuesday. I need to figure out what to do a stream on. Oh yeah, Terry Rose, Ohio. I can do that. But like some of this stuff I need to prepare for. Like the Terry one I need to do some research for. It doesn't have to be all long. Yeah. Just rant and unwind. I mean, that's usually what I do. And I still want to do the what's his face? Curtis Flowers case. Maybe I'll do that tomorrow. But all right. I'm gonna call it a night. Thank you for tuning in. See you guys soon. And just raise or lower. I don't know, probably both. Check out qualified indifference. I knew that. You know, last time I had a physical, my doctor, he asked me about my job right before he took my blood pressure. And he was like concerned for me when he took my blood pressure reading. Because he asked, I started explaining stuff about like Moontook. He was like deeply concerned. But then I like went to a happy place and it was fine. That's kind of funny. Any updates on Quay Marvis Nichols? I don't know actually. I can check that out there. There's a Quay case, and then the other. There are a couple others that I have suspicions of different kind of stress tests. Yeah. But okay, I'm calling it, guys. And yeah, I'll see you soon on Twitter or on here. Yeah. Have a good night.